Thank you very much. Ladies and gentlemen, we're going to start the meeting. If somebody has their cell phones, can you put it on vibrate, please, or off, whichever you like. I'm Mayor Patrick Therrien. We're starting the meeting at exactly 6 p.m., calling it to order. All the council is present. I'll identify them in descending order as Councillor Fuel, Councillors Kaczynski, Miller, and Warren. We have adoption of the agenda. That's item number 3. This is the special meeting for July the 27th of 2026. Go ahead.
Thank you, Mayor. Point of order here, because as you may not be able to see, there's an overcapacity in this room, but there's a lot of people who are outside who want to speak tonight, who actually don't have seats, who are going to be what I would call disappointed, upset, frustrated. I don't know how you could sugarcoat this, but is there not a better venue that we would have anticipated to have hosted this at? Was there not better accommodation for the people of our community?
Thank you.
Why are we closing the door?
We've had, we have a camera, or we have
So then you go
TV.
out there, Mr. Mayor, and see how it is.
We have TV monitors out there, and we've had it done before, so I'm not sure what's the big deal this time.
Because
so
when
we
you're
do
one of
have
the public,
a foyer area.
When you're one of the public and you get locked out and you're out there, you're not going to be very pleased with this situation either.
They're not getting,
you're very fortunate you're sitting where you are for another 93 days. But after that, you're going to feel what the rest of our residents feel, excluded.
Thank you. If somebody has wants to come up here from the audience, they can do so. That's coming up here, saying their opposition or for, and then they can leave if somebody gives up their seat. Otherwise, the fire code allows us for the people in the seats here, and that's it. It's a fire regulation, and that's what we have to adhere to. No, I don't. I'm not a fireman. Councillor Miller?
Thank you, Mr. Mayor. So did we not anticipate a large crowd?
But you know,
but what? What's the excuse?
There's not an excuse. We can't have large venues at all the times, and we have done so. But this is something that's not excluding everybody. We do have a foyer area out there, and that's what it's meant for, is an overflow, and that's what we're utilizing it for. When this was designed, it was designed for 50 people, including council. And we're adherent to the fire code. That's a fire code regulation. We can't not obey the fire code. If something happens, then we're going to be liable. Okay, let me just start with the meeting here, and then we can get into questions.
No, Mr. Mayor,
after.
we not start the meeting. We have to talk. So, how about if you get invited to a party? If somebody tell you, okay, you go to the basement. The party is upstairs. How would you like that?
Well, I've been to a lot of parties where I've been in the basement. So.
No, but everybody is in the basement. Not that some of the people are in the living room and some people are you send them to the basement. It shouldn't be like that. So I think we have to make motion and let council decide that if we have proceed with this meeting or we adjourn and find bigger venue so everybody cannot hear this.
I think it's on the agenda. There's certain people that want this to be delayed, and they're trying to get that delayed. We have a venue here. The venue is done us fine, and the venue is working fine now. So why would we go to another venue at this time and place? We have the facilities here. Let's utilize that. We spent the money for this chambers as well as the RM office here. It's working fine. I don't know. You're the only one that seems to have a dispute with that. Anybody who wants to talk can come in here and talk. Okay, so let's get on with the agenda. No, you can't. Sit down, sir. So what we'll do is, let me get on here. I want to call the meeting to order. Can I get a mover and a seconder, please? Councillors Fuel and Therrien. Okay, adoption of the minutes, or adoption of the agenda, sorry. Can I get a mover and a seconder for the adoption of the minutes? That's item number 3 on the agenda. Mover and seconder, Fuel and Warren. Councillor Miller.
Mr. Mayor, it has come to my attention that the agenda was abruptly changed only hours ago. To be frank, I'm a working stiff, partly, and I didn't have a chance to go through the changes on the agenda. I'm just wondering, why would the administration change the agenda and items on the agenda only hours before this meeting? Did the public have an opportunity to explore all the details of the changes?
I'll defer. Listen, people, like, you're not going to get nothing done here by us hearing the voices here. Just let me talk, let other people talk. The fact is that there's presentations that were sent in at 4:59 p.m. There was provincial from the provincial municipal planning department there that was sent in today. We got the first large meeting or large printouts here that was on the 23rd of July. So there's nothing that's been held back or slowed down, but yes, there is a hell of a lot of stuff to absorb. And I've absorbed most of it there, except for the two delegations that came in late. I haven't had a chance to even read those. Go ahead.
Thank you, Mr. Mayor. Respectfully, has council had an opportunity to look at the provincial report and or had a briefing or any discussion whatsoever on this new information? I can answer it for myself. No, council has not met, whether privately, with our planning department, with the provincial representatives, or anyone else. So I have, to be frank, I'm inadequately informed on this particular project. And I think you would be too, because we as collectively haven't had an opportunity to discuss it.
Well, Councillor Miller, you do work and I don't, except for in this job here. I have had a chance to read it there and go through it, but I understand your position. So if you haven't had a chance to read it, then I understand that.
So I'll just maybe
Deputy...
add that administration did update the agenda with anything that we received up into our office hours at 4:30 p.m. And there is still opportunity to introduce new information during the public hearing up until the public hearing is closed. So there could be new information that will be introduced that obviously no one will have seen before the agenda was posted. So I don't think that's anything out of the ordinary. We will continue to update the agenda up till 4:30 with any new submissions that we got. Obviously, that we got a small revision from the province as well. So we did post that. If council feels like there's more time needed, then you just don't close the public hearing tonight and you take some time for everybody to review that information.
Sir, what are you doing? No, you sit down and we'll call you up when it's time. Good, no. Okay, how's that? Testing 1, 2, 3. Okay, I'll try to get closer there. Deputy Mayor?
Yeah, I recommend that we go on with this. We have everybody here tonight. They can speak. I agree that we should then look at picking another date later on so we can review all the documents. And then administration gets a chance to look at the Manitoba province report again that was sent to us today. I know there's a couple more objections that came in. I printed off the ones that I could. There's 2 again that came at the very end that wasn't able to do. So let's respect everybody. Let everybody speak today. That's why they came. We will not close it today, in my opinion. We will leave it open and we will make another date to come and carry on. Thank you.
Thank you. Councilor Warren, did you have anything?
I did have my hand up.
Go ahead.
Oops. I did have my hand up. Thank you, Mayor. The reality is that we did pass that resolution at council that everyone has 15 minutes to speak. So you will be heard, whether you're sitting out in the foyer or here. You can speak on your objection or your if you're in favor or just for information. This isn't closing today at all. We know that we have new documents. We know we have more letters of objection to read. This is not a one and done. This is just the beginning once again. So we will continue.
Thank you. Councillor Kaczynski.
Thank you. So I want to ask you, Councillor Warren, how it's going to happen if people want to come and speak here. So we're going to ask somebody who is in the audience to relieve their place and go and listen outside. And how many times we're going to do that?
And I think
how that you invite the guests to the meeting, to your party, and now you're gonna remove people because somebody else have to come here and speak because
I
it's
think
only
people,
40 people allowed in this chamber.
Councillor Kaczynski, I think that people are respectful enough to one another that once somebody speaks, they don't want to sit here until 10:30 at night.
Why
Or they
not?
may.
Why not? Why not?
They may.
Because you don't.
Why are you suggesting like that?
I'm just, well, thank you very much, Mr. Akins. The reality is that everyone will speak, whether it's today, tomorrow, or the next day, whatever date we make. We passed that resolution.
Okay, thank you,
I
Councillor
want
Warren.
to first of all ask, like, who called this kind of special meeting for today, and why?
Um, we had to have a maybe
Not we. Who called the meeting, please?
Wasn't
I'll
we?
refer this to our CEO for an official answer on that.
So following discussion with council, the mayor did call a special meeting for tonight based on administration's recommendation to proceed with a special meeting. We assume that this would take a few days to get through this hearing. So that would be at our recommendation to hold this. We have had overflow in the past, and we have a staff member out there. If there's someone that wants to speak, they'll be brought into the council chambers. They can speak into the Zoom computer, and then they will go back out to the overflow area.
Secondly, I want to ask how we even proceed with the first reading on this zoning bylaw when we don't have no documentation coming from the province. Administration knew that this is going to be coming back to us. So how we can proceed even with the first reading that we didn't have the information? The zoning bylaw information wasn't completed yet at this time. Now we're making addition that, so how many, we already have 7 different versions of this zoning bylaw, and everyone is different. So how we know how many changes was made at here for this public hearing?
So this is the usual process that we follow. We would give first reading to bylaw, and then it's distributed to the provincial departments. So that has taken place, and now we've received the report with the provincial comments so that we can proceed with the public hearing.
So if province gonna make more revision and put different information, we're gonna have another public hearing? Because they might still change their mind. They change mind within 2 days or 3 days over
So
the
if
weekend.
council doesn't close the public hearing tonight, we can continue to take new evidence and make further changes to the bylaw if that's what council wishes.
And how we gonna learn what's in it? I see only one because we didn't have enough time. I see one that we removed from our that it's required. They remove province remove the aggregate provision and that whole documentation. How this happened? Who asked for it and why was removed?
Well, the province is here, so they can answer questions as well tonight if council wants to direct those. But I believe most of the presentations from the public were based on the bylaw that was posted on the agenda and sent out for the notice over 25 days ago.
Why we even agreeing to remove the aggregate from our brand new zoning bylaw?
Well, I think we need to pass the agenda and open the public hearing, and then those questions can be asked.
I agree. So why don't we open the agenda? We still haven't passed the agenda here. If there's any other changes?
Excuse me, but the public even doesn't know what question to ask because they even don't know what's in it.
Well, that's something we're going to be discussing, but we've got to pass the adoption of the agenda first. Then we can open up the public hearing, and then if there's the new information will be discussed by Mr. Doucet there. And if there's more time, and obviously I think we're going to need more time to go through all this, and so will the public, and no less than us, because we got the information late there. As Councilor Miller says, he hasn't had a chance to look through it. The only one I haven't had a chance to look through is for the revised one there, but it's just one little change. It's just a small change. So I think I'm up to speed with regards to that there, but it's a very intense project. It's 8 years in the making there. So So this is the part of the public hearing, and this is what we wanted. You made a resolution, you and Councillor Miller, to have 15 minutes. So let's have the public hearing and go as far as that we can tonight, and then we can discuss it, let's say around 10, see where we're going to go from there, and when the next date will be.
So it was take 8 years and we didn't have correctly done yet, and we want to rush now and make sure that we're going to do correctly. How is this going to happen? In one meeting, we spend, Mr. Mayor, we spend $100,000 and 8 years. How are we going to solve this problem in 3 days, maybe, if this hearing going to proceed with the public?
If it takes 3 days, we'll take 3 days. So I just want to we got to get through the adoption of the agenda. Go ahead, Councillor Miller.
Thank you, Mr. Mayor. I just want to set the tone as well that the RM of Springfield has actually been reprimanded and advised by the municipal board at least 2 times on this particular issue. Once because the admin and the RM's hired consultant tried to portray the changes as minor, when in fact Councillor Kaczynski and I strongly advised that the changes were major. We were correct. Another attempt was more recently initiated, and the municipal board adjourned the meeting due to flubs in communication and the multiple versions of the document. We still don't know which document is live, it seems, but the one on the website is. Few knew what version was active or the final. The mayor is quoted as saying in the clipper there were technical errors. Again, Councillor Kaczynski and I, on behalf of the public, tried to avert this, but yet the admin and the majority of council was chastised by the municipal board for this again. So we are 2 out of 3. 3, because of majority, doesn't make it right. The provincial report was made public only on June 24th or July 24th, Friday. The public and council had not had a chance to reflect, discuss, or conceptualize the meaning of this document. When the mayor says, I didn't have a chance, I meant collectively as well. We have not had a chance to discuss this. We need to get this right, as Councillor Kaczynski says. We've invested 8 years, 100 grand into doing a document that doesn't seem to satisfy and changes a lot. There is a lot at stake here. Let's not undermine this. There's lots of people who want this document done for special interest purposes and for perhaps selfish purposes, but go beyond that. And I know residents need to know more, how this will affect them and what is the motivation. As Councillor Kaczynski said, the aggregate element of it was just taken out. What was the motivation? What were the purposes? Who's doing this? Are we opening the door to silica sand mining? And with any of these changes? Are we playing favorites to any landowners or developers? Are we giving development control to unelected officials who are not answerable to the public? And what I mean by that is administration. These are just some of my questions. I am delighted, absolutely critically thankful for people coming out tonight, taking their evening, their wonderful summer evening, a few that we get to share. I'll be listening, taking extensive notes and all the rest of it. But Councillor Fuel and Councillor Warren, you have a lot at stake here. The mayor doesn't. We're up for re-election. If we don't get this right, there's going to be casualties. And what I mean by that is some of these seats will change. It might be mine, it might be yours. But let's get this right. Let's make sure that it's a perfect document for all of us, for all of our community going forward.
Thank you. Okay. If we can, folks if I can get a vote adoption of the agenda with a show of hands. Councillors Warren, Fuel, and Therrien. Those opposed. Councillors Miller and Kaczynski, so passed. I want to lay a couple of ground rules, folks, there before we get started here. Just treat people with respect, murmuring in the audience there to try to disrupt if there's disruptive behavior. It'll have to be addressed. This is a meeting for the public there to express their views. People that are trying to take advantage of the situation there, they'll be warned the first time of the disrespectful behavior. Possibly a second time there, but in the end it'll be my choice to see whether it's disruptive behavior and it's impeding our progress in the meeting, and we'll call the police if necessary if the person doesn't leave. So a reminder to people of all the rules there, and act respectfully and we can get through as many of the persons as part of the public hearing in short order tonight.
Mr. Mayor, point of order.
Yeah.
Are you threatening already our residents before the meeting started with the police?
Just laying the rules. Just laying the rules. Okay, it's just
What rules?
simple.
Calling police?
So people,
like how is this even possible that you're starting meeting threatening people with the calling police of them?
It's not a threat. It's right there
Well,
in
what do you call that?
bylaw.
What do you call that?
If somebody's disruptive, it shouldn't be a surprise to him or her there that they'll be warned the first time there. They may get a second time there, but when they're told that is disruptive and they have to leave, they can choose to leave or not. If they don't leave, then they'll be calling the RSMP and we can go from there. That's just part of the procedure. We've done it for 4 years. So what's the difference tonight?
Mr. Mayor, you was disruptive, lots of meetings and nobody called police on you, but maybe tonight gonna happen for the first time.
Okay, that's great. Okay, so for the public hearing there, I got to read the following format here. The public hearing process is as follows. The public notice will be read out indicating the intent of the application. Oh, okay, sorry. Sorry about that. The public hearing process is as follows. The public notice will be read out indicating the intent of the application. The development officer will provide a summary and information pertaining to the proposal. Those that wish to make a representation speaking on a planning matter must sign in their print their name, whether they're for or against there. You'll be given an opportunity to make a presentation on the matter before council, going up to the podium there. Opportunity for presentation or to speak on the matter will be in the following order. Applicant will speak or make a presentation on the proposed application. And that'll be Mr. Martin Sandhurst tonight on behalf of the RM. Inquiries, this will be given the opportunity to ask for a clarification on what the planning matter is proposed. Those in favor, this will give those that are in favor the opportunity to speak, and those in opposition, this will give those that are in opposition the opportunity to speak. When you begin speaking, please state your name and address. A reminder that at all times you direct your comments and questions to the chairperson, that is myself and no others. Once everyone has had an opportunity to speak, council may close the public hearing on a matter, after which further input from the public will not be permitted for legal reasons. It is important that if you wish to speak and be heard on a planning matter, excuse me, now is the time to make representation. Again, once I, the chairperson, close the public hearing, no further discussion will be allowed. I just want to start. We're going to have a lot of people. We got 15 minutes per person there. If some of the presentations are just redundant with the same stuff there, I'm going to make a note of that there, and hopefully that'll allow people to more people to give their insights there on it. The first person up there will be the applicant to speak. Yeah. Okay, well, we're going to make a presentation there from the applicant, and then we can go into the inquiries, those in favor and those in opposition.
Mr. Mayor,
Councilor Doucet.
excuse me, Mr. Mayor, I will present my presentation on the process. Mr. Sandhurst will go to discuss the bylaw, and then we'll have the public hearing for, sorry, then we'll have the public hearing to discuss those in favor, those in opposition, and those for information.
Okay.
Okay. So I'm going to give a bit of a background information on this. Following the adoption of zoning bylaw, or sorry, following the adoption of the Springfield Development Plan 18-09 back in February 2019, the RM of Springfield issued a request for proposal for the preparation of a new zoning bylaw and 2 secondary plans. In June 2019, Council awarded the consulting contract to WSP. Specifically to the new zoning bylaw, WSP's proposal included the following deliverables specifically to the zoning bylaw. Phase 1, there was a background review, there was a steering committee that was formed, there was initial workshops, development and delivery of the first round of public engagement. Phase 2, there was the preparation of first reading of the zoning bylaw, first draft of the zoning bylaw, coordinated and facilitated steering committee workshops, developed and delivered second round of public engagement. Phase 3 involved preparation of the final draft of the zoning bylaw, prepared and delivered the third round of community engagement. Phase 4 was prepare the first reading version of the zoning bylaw, prepared second reading of the version bylaw, attend municipal board hearings if required, and prepared reading version of the zoning bylaw. Back in November of 2019, a series of in-person public engagement sessions were held to gather input from the community members on the new zoning bylaw. December 2020 through January 2021, the new draft zoning bylaw was presented in an online format due to the COVID pandemic. Feedback from the draft new zoning bylaw was sought through an online survey at the time. Another round of public community engagement occurred back in May of 2021 throughout a series of online open houses. First reading of the draft zoning bylaw 21-25 was given September 2021. Following the public notice period, Council held a public hearing for bylaw 21-25 in October 2021. Second reading of bylaw 21-25 was given on June 2022. Due to sufficient objections under Section 76 of the Planning Act, bylaw 21-26 was referred to the municipal board for hearing back in February of 2023. Prior to the hearing commencing, during a consideration of a preliminary matter, the Arma Springfield Legal Counsel committed to council holding a second public hearing. As a result, the municipal board ruled the referral not valid. In May of 2024, a series of community information sessions were held to provide the community members with information concerning the following: the 53 alterations that had been made to the draft new zoning bylaw 21-25 between October 2021 and the public hearing, and June 2022, the second reading. The direction of the municipal board included in the April 2023 order concerning the municipal board requirements back in March of 2023 order to create a new MRP, Industrial Resource Production Zoning District, including a definition of the industrial resource process, and to rezone property near Vivian to MRP district. And zoning map 11 changes approved by council between January 2022 and May 2024 under zoning bylaw 0801. In June and September of 2024, council held public hearings for bylaw 21-25. Second reading of the bylaw was then given back in December of 2024. Due to sufficient objections to bylaw 21-25 was referred to the municipal board for hearing in May of 2026. Prior to the hearing, during the consideration of a preliminary matter, the municipal board determined that the referral was not valid. On June 16th, 2026, council resolved not to proceed with zoning bylaw 21-25. The draft zoning bylaw 2609 was prepared. Although the draft 26-09 bylaw is substantially similar to the former 21-25 bylaw, there are a few distinctions summarized in a table provided to council and within my report, and which Mr. Sandhurst may be speaking on later. First reading of the bylaw of 2609 was given on June 25th, 2026 under resolution 26264. Notice of the public hearing of bylaw 26-09 occurred in accordance with 168 of the Planning Act. Notice to the Minister of Municipal and Northern Affairs, June 26th, 2026. Notice to the surrounding municipalities and planning districts, June 26, 2026. Notice was posted at the municipal admin office, municipal planning office, public works office, water and waste office, and on the RM website, all on July the 3rd, 2026. Notice was advertised in the Clipper Weekly and Winnipeg Free Press newspapers on July 9th and July 16th. At the time of the submission, we had received the following, which has been updated here. We had one letter of information for clarification. We had one letter of no concerns from the RM attaché. As of this evening, we've received 10 and possibly an 11th after 4:30 of letters of objection. We also had received a petition with 944 signatures on it. They yet still have to be confirmed. We have received a revised report as of 3:30 today from Municipal and Northern Relations. In accordance with Section 68 of the Planning Act, Council must adopt a zoning bylaw that is generally consistent with the development plan and any other secondary plans in effect in the municipality. Following the public hearing in accordance with Section 76, Council may proceed to give second reading and third reading or pass a resolution not to proceed. Council may consider accepting the recommendations within the Municipal and Northern Relations report. I would recommend that we continue with the public hearing, then reach out to Municipal and Northern Relations to further discuss any modifications to the subdivision and also any of the concerns found by the general public this evening. We could discuss that with council as well. Thank you, Mayor Therian.
Thank you, Mr. Doucet. Mr. Sandhurst? Sir, why are you keeping on going up there? I haven't called you up yet, and Mr. Sandhurst is still talking.
Sanders.
No, sit down, sir. Sit down, sir. It's Mr. Sandhurst, he's the applicant. No, sit down, please. Sit down. Sit down. Is Martin going to be talking?
Yes.
Okay, Mr. Sandhurst?
Thanks for your attention. Sorry. Thank you, Mr. Mayor, for the introduction. Just in case anybody missed it, my name is Martin Sandhurst.
Sorry, Councillor Miller, you got your hand up?
Yes, thank you, Mr. Mayor. Point of order. I have been advised that there's people outside the gallery, outside of the chamber here that need to sit down. Is there no way that our RM can accommodate people with extra chairs? I know when I came into the chamber, for instance, Mr. Giesbrecht, I know he has a disability. It's on the record. Why are we not accommodating people who have special? Thank you, Mr. Byers, for pointing this out. I don't know why the mayor doesn't want to hear you, but it goes. Please.
Thank you.
May I proceed, Mr. Mayor?
Yes, please, sir.
Okay, sorry. Just for the record, my name's Martin Sandhurst. I'm the planner of economic development. I work for the CAO. I've been asked to represent the municipality in its proposal to adopt zoning bylaw that's in draft form right now, 2609. I have a brief presentation on that basis that is focused on 5 questions. I'll ask the questions and answer them. It's pretty basic, and Mr. Mayor, I'm going to keep this to within the 15 minutes that others have been allotted. On that basis, I'm going to skip through the detail that I had that your planning director provided on the engagement process and the chronology under 2125 through to council giving first reading to 2609. Okay, I'd be happy to provide additional detail If council is interested, Mr. Mayor, you'll have to prompt me on that basis. So question 1, what's the test? From a big picture perspective, when considering this proposal to adopt a new zoning bylaw, council must consider the following. The Planning Act Section 68 states, a municipal council must adopt a zoning bylaw that's generally consistent with the development plan bylaw and any secondary plan bylaw in effect in the municipality. The Municipal Act, Section 1 says shall be done or must be done. If those words are used, the obligation is imperative. Section 1 tells us of the Municipal Act that as a municipality, we have an obligation under the Planning Act to adopt a new zoning bylaw. This obligation has been unmet since the development plan was adopted in February of 2019. Question 2, now what? For anyone wondering really what the heck we're doing, we have no choice. We have to adopt a new zoning bylaw. Submissions to the recent municipal board hearing included a lot of comments. Amongst these comments are the following. There have been several versions of the bylaw. It's made it very confusing for the public. Various versions and irregular procedures have confused the public. Deeply concerned about multiple evolving versions of the bylaw. So for anyone wondering why there's a different bylaw number, we have no choice. We have to make sure council members aren't confused about what they're considering. After looking at several options to achieve this, we received direction from council to proceed with this option. Because this option is simple, because it's straightforward, and because it's intended to deal with the potential confusion head on. Question 3. What happens to all the work that was invested in draft zoning bylaw 2125? Even though council voted on June 16th, 2026, to not proceed with zoning bylaw 2125, none of the inputs to or the feedback on 2125 have been lost as a result of going down the path of 2609. Despite the new bylaw number, draft zoning bylaw 2609 is the product of consultant and municipal expertise, plus the following steps in sequence. And I'll just give you the headings because Mr. Doucet has already provided these details in reading from his report. Step 1, the development plan process. Step 2, zoning bylaw and secondary plan process that were undertaken. Step 3, the council public hearing in October of 2021. Step 4, the municipal board appeals. Remember, there's the CO Silica appeal. There was also the referral of 2125. Step 5, the zoning bylaw 2125 process was re-engaged in May of 2024. Step 6, council gave public hearing in June through September of 2024 on zoning bylaw 2125. At that time, council received representations from the community in accordance with the act before giving second reading to that bylaw in December of 2024. Step 7, the municipal board referral. June 2026 municipal board order was released. On that basis and specific to community engagement, which again, Dan provided more detail on. I'll provide additional if you guys are interested. I'd like to enter an exhibit, and Mr. Mayor, would I hand that to Ms. Catalia?
Yes.
Okay, so this is a record that was provided by our consultant, WSP, of the community engagement process. And I want to make sure it's abundantly clear. There's information about consultation that was done with the public on both the 2 secondary plans and the zoning bylaw. Okay, so they're both done at the same time. So you'll find details about all 3 of those products. I'd also like to enter as another exhibit specific to the community engagement regarding the May 2024 engagement process period. The exhibit includes the public notice and the capture of the presentation boards for the community information sessions that were held at that time.
What time is this? What year?
No,
Mr.
just
Mayor, would you
keep
like
on
me to
going.
answer that question?
No, just please, we'll
you.
get this out of the way.
Extensive efforts were undertaken to determine future direction for land development at the municipality and subsequent efforts to develop rules to ensure land development remains on track. Question 4, what's included in the draft zoning bylaw? Beyond the test that the bylaw be generally consistent with the development plan, what must and what may be included in the new zoning bylaw? The Planning Act is explicit about mandatory content, Sections 71, subsections 1 and 2 provide details of what the municipality must include in the bylaw. Must divide the municipality into zones, must provide permitted and conditional uses for each zone, set out procedures for applying for and issuing permits, non-conforming certificates, zoning memoranda, and similar, must prescribe development requirements for each zone based on the development plans, secondary plans, character of each zone, existing and proposed uses of land and buildings in each zone. Section 72, subsection 3, we also must establish in our zoning bylaw siting and setback requirements for livestock operations. Draft zoning bylaw 2609 includes all mandatory content as prescribed under the Municipal Act. In terms of discretionary content, the Municipal Act also allows the municipality discretion to add, to do things beyond what's required to be included, but that's prescribed as well. We can't exceed those authorities. So section 71, subsections 3, 5, and 6 provide these details. And I'll go through a few of these. Again, if you guys have questions about that, please let me know and I'll provide additional detail. So we may include in our zoning bylaw provisions concerning construction or use of buildings, dimensions and area of lots, number, lot coverage, floor area, yard size, dimension and location of buildings, design details of buildings, location and height of fences, landscaping, parking, and loading facilities, and so on. We may also impose requirements for providing affordable housing. We may also allow for bonus development opportunities in exchange for public benefits. Again, this is discretionary. We're not required to do this. We may do this. The draft zoning bylaw 2609 does not include any provisions other than those authorized by the legislation, and that includes the Planning Act and clauses under the Municipal Act as well. What's changed from zoning bylaw 2125? It was recently abandoned, and what we're dealing with tonight, draft zoning bylaw 2609. Substantive changes include more definitive terminology. May or should terms were replaced with shall 26 times. Sign definitions were added where they were previously omitted in error from 2125. Advertising sign is now specified as a principal use of land where it was previously specified along with other sign types as an accessory use. Planned unit development is now specified as a conditional use in the RS, RT, RM, and HA districts where this use was previously permitted. We also included more refined railway facility setbacks to be consistent with the FCM RAC guidelines for spur lines, branch lines, main lines, and freight yards. Finally, we introduced a couple of map changes in order to incorporate zoning amendments under bylaw 0801 that were approved by council subsequent to the June to September 2024 public hearing. We also made some housekeeping changes to include some typographic and grammatical errors that were corrected. We reinserted some section headings that were accidentally missed, and we reworded some for accuracy. And there's a general tightening of terminology throughout the document. Question 5, what process is being followed for adopting the zoning bylaw? The Planning Act, unsurprisingly, specifies the process for adopting a new zoning bylaw. There are mandatory procedures, specifically 73.1, 74 subsection 1 to subsection 3, 75, 77 subsection 1 to subsection 5. They specify procedures that the municipality must follow for adopting a zoning bylaw, which includes tonight's public hearing. 166 and 177, those sections specify the public notice requirements the municipality must follow for adopting a zoning bylaw. Draft zoning bylaw 2609 adoption has followed the procedural and public notice requirements as specified under the Planning Act. In addition to the mandatory procedures and notices, the municipality undertook discretionary engagement. In addition to the mandatory procedures and notice provisions, Springfield undertook community engagement consistent with best practices outlined in both the Municipal Relations Guide to Zoning Bylaws in Manitoba and the Planning Act Handbook documents. The community engagement process undertaken during the November 2019 through May 2021 period included, as I understand it, I wasn't with the municipality at the time, so didn't participate, but it included a combination of consult and engage types as defined by the International Association of Public Participation. Choices concerning which types of, the community engagement process undertaken in May 2024 was an informed type, again, as defined by the International Association of Public Participation. Ms. Catellier, how am I doing on the 15 minutes?
344.
344 remaining, thank you. Finally, choices concerning which types of engagement to utilize at which stages of the overall community engagement are consistent with IA2P practices based on both the timing of the engagements and the nature of the materials being considered at these times. Mr. Mayor, that's a wrap in terms of my presentation. As the applicant, I understand I'll have the opportunity to respond to objections once all the objectors have been heard.
Thank you very much.
Yeah.
Then we'll open it up to the public at this portion here for inquiries. And that's, we'll give you the opportunity to ask for clarification on the planning matter as proposed. I will select, sir, sit down.
Oh, sorry.
So who wants to make a presentation? Who wants to make a presentation? Inquiries. Okay, Mr. Breer. Sir?
Oh.
This is for inquiry.
Questions?
Inquiry.
Is this, I can ask questions?
It's an inquiry. Yes, go ahead. We're not going to be going back and forth bantering all night here. If you got a question, we'll try to answer it.
Okay.
State your name, sir, and the time will start.
Hello, my name is Craig Byers. The question that came earlier was about if we could have it so everyone could sit in the foyer, because we're talking about we may go to 10 p.m. and I just hope that everyone in the hallway could be able to stand there for till 10 o'clock. I know I couldn't stand for 4 hours. And I don't know if everyone needs a chair or not.
We've already addressed that.
Thank you. I'm going to ask some questions to the counselors regarding
Any questions, folks, got to come through me first. Yes, to the chair. Yes, go ahead.
I want to ask questions to my elected officials.
Through me, sir. Through me, sir. Who you want to address it to, then we'll go from there.
Okay. First question I'd like to ask to Councillor Warren, please.
Okay, what's the question, sir? Go ahead.
Oh, okay. So can I ask it to?
Ask me the question, sir.
Okay, so now that one's going to wait. And now my question is, how can I speak to each of my elected officials? I'm here at the public hearing.
You're doing it now, sir. Speak
Great,
to me, and then I'll ask.
But you're stopping me.
I'm not stopping you at all, sir. The procedure is you go through me, and then if it's a question for Councillor Warren, I'll ask Councillor Warren to answer that.
So you're going to screen it, basically?
No, I'm not going to screen it all. Just ask the question, sir.
Okay. So, Mr. Mayor, my question for Councillor Warren is, does Councillor Warren fully understand this 92-page document that we're speaking about right now? And I've heard comments that not everyone's had a chance to see all the latest revisions
Some
and
haven't, that's
versions?
right. Yeah.
Okay, so has Counselor Warren had the opportunity to read all the most up-to-date versions that have come in even minutes before this meeting? And does Counselor Warren know how this will, or sorry, one question at a time. Has Counselor Warren read and is aware of all of the most recent changes, even just before the meeting?
Thank you, Councilor Warren.
Thank you, Mr. Byers. I have not been able to read the last few things that have come in. That's why this is a public hearing, so that we hear more information from the residents. And we look at everything that was submitted and the new information that comes from the province. And as well as everyone here this evening or the next few days. We take all that information, and I take all that information back and I look at it all. And I am not afraid to ask our planning department, who is very knowledgeable on the certain issues. So I have read some. I have not been able to dive deep today, but I have read some, yes.
Okay. Mr. Mayor, does Counselor Warren understand everything that's written in this document, this proposed bylaw?
Go ahead.
There are things that a lot of individuals, including myself, don't understand. I'm the first probably to admit that. Show me somebody here that actually can understand every single thing in this document. It's about trusting your planning department. You, listen, they are qualified individuals that helped with this document. They did the public consultation way before I was here, right? So this is not new. When there is an issue, even with 0801, I had issues. And if I didn't understand 0801, I went to the planning department, who understand way more than I do. Or you can seek out the community planning office, who would explain more into it. It's not everybody here understands that full document. And if you do, well, congratulations. But it could change, right? Like you said today, and I've seen it come in, that things are changing all the time. So we need to take that information back, go through it, work together, and make a document that works for the entire municipality.
Okay, thank you.
Thanks.
So would it be fair to say that the council is not in a position to make a decision or a second reading right now, because there's a lot that everyone is not familiar with in this document?
There's a lot to be read, and there's still some councillors that haven't read it all. I've read it all, apart from the revised portion, but that's a small addendum to that. So I think that's a fair assumption there, that we're still getting all the information. Yes. Okay.
Another question toward Councillor Warren. You mentioned trust. Trust is very important, especially about a large document like this that'll affect our planning and everything. I found from your election campaign in 2022, it's some of Melinda's commitments and about Melinda. And I'd like to read some, not all of it, just some that's the most relevant.
Sure.
So I just want this on record, and this is some of your commitments that you've made for us, residents.
Yep.
I believe in local government, and decisions made by council should be transparent and include involvement with the residents, in particular those who would be most affected by council decisions. I will listen and advocate on your behalf. I will promote accountability regarding council decision-making and for providing details, rationale, and financing plans for major and long-term projects before they start. And then a little bit more about yourself. Over the past 4 years, council has dismissed concerns and needs of existing ratepayers and focuses only on more development. I'm running for council because I would listen to the people and be a strong voice on council for existing Springfield residents and their concerns. And just the last little bit here, key concerns that you have heard while going door to door: protecting our drinking water, keeping our taxes in line and limiting borrowing, land use planning matters not following existing bylaws that have been implemented in consultation with the public, and keeping up with multiple amendments. And then the last item of your concerns: unresponsive council who dismiss resident requests and concerns. So all my questions are coming from the position of we're asking you to make decisions and advocate for the best interests of the residents.
Yes, sir.
And with that, I was wondering if you could provide a little more description of what kind of work you've been involved with this. Like, how many hours have you spent consulting with the planning department on this?
I don't know exactly the number of hours, but we do have conversations. I'm so glad that this is we're supposed to be talking about bylaw 2609, not necessarily my thoughts totally.
I agree with Councillor Warren.
You know what, Mr. Byers, I've always listened. Yes, that pamphlet from 2022 was when previous council never called me back, never listened to what I had to say. And yes, we were all dealing with some matters that could affect our drinking water. So everything I've said in there, I will always listen to you. I have no problem. But we are still here. This is a public hearing, which will go on for more than likely days. And the reality is we are taking all this information back and figuring it out all together. It's not a simple, we're done. So thank you for bringing up my pamphlet from 2022. And you already asked me for my pamphlet for 2026. So I understand where it was going. And it's along the same lines. I will listen to you, Mr. Byers.
Okay, thank you.
Thank you.
And Mr. Mayor, I would like to know what changes Councillor Warren has made to this document to benefit the residents of Springfield.
You know, I think this is not an election to start nitpicking at some of our candidates there. You're reading from a list and it seems like it's prepared. Hopefully you prepared it.
That's right.
There.
This is my
So
own
the
handwriting.
fact is, I don't think going after Councillor Warren is appropriate. I think you're focusing on her for whatever reason. You're focusing on her. The job is the same as what all council here. We're trying to get all the facts here. This really doesn't have much to do, if anything, with 2609. She's here representing her ward. She's here representing the RM of Springfield. I think what the second question here, the first one was just borderline, but this one here is just blatant electioneering. You're trying to belittle Councillor Warren. She's not here to be used as a tool for your notes there. She's answered the question there, and I think the first question was fine. The rest of it, I think you're going after Councillor Warren because she's a candidate. That's essentially it. If you've got a question, it should be focused towards 2609, and it doesn't.
The last question I asked was exactly focused to 2609. I asked if Councillor Warren, what changes she made to 2609 to benefit the residents.
To benefit the residents, everything we do is to benefit the residents. What Councillor Warren, I'll let her speak to that if she will. But this isn't attacking Councillor Warren. I take offense to your position there coming through. You seem like a nice guy, but what you're doing there isn't very nice. If Councillor Warren wants to answer that, if not, then we can proceed.
Ideally, the issues that came up before And I had a few residents talk to me before. People are concerned with, obviously, we're all concerned with the aquifer and the limitations on the natural resources. Are we not? Like, we should be. And the reality is that I talk to people about different things. I bring that information back. I don't always, how do you say it? Well, basically, if I hear something, I take it to the planning department. So people talk to me all the time, Mr. Byers, and you do as well. And I've talked to other residents. I've sat down with them. I've talked to them for hours. People are, thinking that if we change something, then everything's going to be changed, and you're going to lose your right to your land. You're going to lose how many livestock you can have on your land. But that's not the case. Like, there's always a way to amend, and we need to do a lot of protecting our resources, including our water. Our water is very, very important.
Yes.
So when we look at the development plan and then you look at the zoning bylaw, they have to work together. And it's basically the development plan and the bylaw. This bylaw directs that. And so we need that. So I can talk in circles because I feel like I'm talking in circles right now because I've just been. So, but the reality is that we have a relationship with departments. We talk to the province. People know the concerns that Springfield has. We've had multiple public hearings. We've had multiple open houses. And everybody has had their say. So can I tell you exactly everything that I've put forward for bylaw 2609? No, I can't. Because every time I hear something, I bring it up. Say, has it been changed? Is it on there? These are questions that we bring to the departments. I can't count however many times I've brought something forward. I'm not going to say that it is what it is.
Okay, so you're telling me you can't say how many changes you brought forward, but can you tell me one?
No.
Okay, no, I
No,
think
Mr.
that's
Byers,
enough. Your time is up,
We can have a
sir.
conversation another day.
Okay,
Your
because
time
I
is up,
think
sir.
this is my time up. How
Your
much
time
is
is
it?
up. It is up.
Oh, how much? Oh, really? I think I was talking for about 6 minutes
15
only.
minutes.
No,
But,
it's 15 minutes.
Okay, I think these are all relevant, and this is all to the point that it can't be rushed. And I don't know where there's been multiple public engagements about 2609.
Thank you very much, sir. Okay,
I hope someone else
you made
can
your
carry
comments.
that
Thank you.
question on.
Okay, this isn't a forum for attacking candidates. So I resent the questions there. The first question was just borderline there, as I stated before. This isn't the time and place to start bringing up electioneering. Who's next for inquiries only? Sir? I got you both at the same time. You'll be next, sir.
Oops.
Thank you to the council. My name is Art Mitchell. I've been here as a person that lives here and plays here and does all kinds of things here. And that's been going on for over 40 years. So I'm proud to be part of Springfield. I'm not proud to hear some of the situations that are going on between the people that are sitting out here and the people that are sitting in the council. Quite some time ago, I asked a question at one of the public meetings. Was there any monetary situations coming due to people that are involved in the council and or behind the council? So since I have found out that some people have got on a board And also one of the situations which I seem to have misplaced the pictures and the script of a group. The first one is called Happy
Does this have anything to do with
Harvest
2609, sir?
Agency. Pardon?
Does this have anything to do with 2609?
Yes, well, it's basically to just talk about 2069. 2069. If I could ask two questions. One, I've heard in the dissertation of two people that have taken a long time of the people's time here,
Yeah.
that we're going to get another meeting on this, the bylaw that they're trying to put through. And I think if I'm correct on that, that there will be another meeting?
Um, we can't make that decision now, but it sounds like we're probably going to have another meeting. All we can do is 4 presentations in an hour. So there's probably going to be more than that amount of people here to do that. So yes, it probably will be.
If your statement of wanting another meeting was correct or not correct?
Yes, and
Okay.
I had mentioned that as well. We've all kind of come to that agreement that that's
Secondly,
likely
based
the
on
case.
that, but could the meeting be held in a place where we can hold all the people that are out in that hallway and a lot more that really want to face up to this particular bylaw? And because
That's
we all have an interest in it.
Well, we're going to be a lot of people are going to be heard tonight there. So if we have a second night, there won't be the same people there. And my position is no. I think we have a facility here that works fine for what we have. The odd time where there's an overflow, people still have access through the overflow there. It costs a lot more money to do so there, and I think I answered that at the beginning there, sir. But with respect, I think this council chambers that we have is, I find, sufficient, but that'll be a council decision.
Basically, the next question is on the same bylaw. I understand that somewhere in the dissertation, we're almost being forced to pass it based on what this gentleman said and the other gentleman that spoke, that it has to be passed. Is that the truth?
No, we like to pass it, but we're here to get people's inputs now for that there. So no, I would say that's a yes and a no. It has to be passed, but we have to do it and get everybody's insight there. We have the provincial report that had come through. It only came through on Thursday evening there. So we got a lot of catching up to do, and now there's another report that came through, basically the same report there with just a one revision that's basically inside there. Instead of them just sending a one addendum to that, they send us the whole report there. You still got to go through it though.
So the bottom line is it's probably going to pass.
No, yeah, it should pass, but it'll pass with the people's input.
You'll pass what the people want?
Yes,
Okay.
absolutely. We're trying to
You hear
get
that, everybody?
sir. We'll
That's
try
what
to
we
get.
all want.
Yeah, but we're elected to make those decisions, and that's what we're here for. And we're
Yeah.
getting your input as well, Mr. Mitchell.
All right. Thank you for your time.
Thank you, sir.
I'm going to let somebody else in my place.
Sir.
Thank you. I'm Ron Hildebrand. I live in Cooks Creek. I've been a resident of this municipality since 1981. Noticed recently that there seems to be a growing number of vehicle sales that have required conditional use hearings. And in the new, or the one that I saw, I'm not sure this is still there, but in the new 2906, automotive sales or rental is defined as a development used for the retail sale or rental of new and used automobiles, motorcycles, or other recreational vehicles, together with incidental maintenance services and sales of parts. This use is now permitted in the commercial highway zone, the industrial business zone, and the industrial general zone. Is this streamlining process to streamline the planning meetings And also, would this remove the opportunity for neighbors to voice some concerns about these applications?
First of all, I'll refer to Mr. Doucet to verify that. I'm not challenging that's what it is, but I want to hear from Mr. Doucet with regards to that permitted use.
Mr. Therian, I'll have to quickly look that up as I haven't memorized the new bylaw as of yet. I'm sure you're correct.
Okay, now Mr. Doucet will verify that. As for lining there, I think we're always looking for efficiencies in our planning, the rezoning as well.
But might this take away the opportunity for people to have input into those applications with concerns
Well,
prior to the use being approved?
I want to see what Mr. Doucet has to say with regards to that.
A follow-up then.
Okay.
My next question is, how would the application for licenses be done in rural areas outside of those 3 zones that I've mentioned?
Of the same question, sir, about the
Well,
permitted
more or
use
less,
for
just
selling
how,
vehicles?
how will those licenses be approved if they're not within those 3 zones?
I guess, go ahead, Mr. Doucet.
As you are correct, automotive sales are permitted in the CH highway commercial,
Right.
in the MB,
Mhm.
being the industrial business, and the MG. Those are principal uses being the main uses. And if you look at the other section, which is called accessory uses,
Mhm.
so you have your principal use as your dwelling, your accessory, your secondary use is your car broker. So in the rural residential, conditional use still. In the AG, still a conditional use. In the AR, still a conditional use. And in the Hamlet, still a conditional use.
Conditional use.
So we're looking at principal uses and accessory uses.
Okay, all right. Thank you. I have another question. And through you, Mr. Mayor, to any of the councilors, or if you can answer it, great. I wanted to know if you could tell me who drafted this latest version of 2906? Who's responsible for drafting it?
That'll be our planning department, and I'll have Mr. Doucet answer that as well.
The overall document was originally drafted by WSP with some revisions done by Mr. Sandhurst, who's a professional
When
planner.
you say original, is that the original 2906 or the previous?
The previous whatever bylaw
Well,
was.
who did this one?
Who did this one? Mr. Sandhurst had done some revisions to it. It's still the same format as the previous one, with some slight revisions as identified in the table.
Okay. Were any counselors involved in the process of drafting this?
Of drafting the 2609?
Yes,
Well, no.
2906, sorry.
2609.
Sorry.
Yeah, I was wondering where
My
the heck
mistake.
is that?
Sorry, my mistake.
No, that's fine. So 2609 is we're of the opinion there. We had two subjects that had come up at the municipal board hearing that were confused on the verbiage there of the resolution there, and it's quite easy to be confused there because it's an extremely difficult process going through COVID and so on like that. So it is quite hard to keep track of all that there. And we felt that if it's confusing, we can go into another bylaw that is streamlined. It's essentially the same one, but it's under a different format, 2609. So starting the deliberations all over again. So
I
we've
guess
done the
I'm more
first
concerned
reading.
about the process, whether it was this one or the previous one. My question is, were any counselors ever involved in the drafting of the document?
No, but we were involved in passing at the first reading.
Right, passing without involvement. I find it really
Well-
interesting that people wouldn't be involved in the process to get a full understanding of what this document contains in order to sit in this room and approve it.
Well,
Without having any meetings with the planning department to discuss issues or ask questions about the new document. It's really interesting how you would expect these people to vote for or
say
against
something.
something
No,
if they don't know
that's-
what's in the document.
That's not correct,
Those
Mr.
are my
Hildebrand.
questions.
Because the 2125, we know that, the council knows all about that there. So we've gone through the almost 4 years of that plan, but it's under the last council that had that 2125 there, that it was adopted to the second reading, then a municipal board hearing, and then that we followed in. So that the plan has been worked out. It's only the changing of the number. That's all that is. The plan is the same. It's the same. So to say that we're not up to 2609, we are. Anybody else for inquiries? Go ahead, ma'am. Is it Elizabeth? Finally got it right after all these years.
Thank you. Everybody hear me okay? Okay. I too am not familiar with this bylaw, so that's
Sorry,
why
ma'am, if you could just state your name
pardon
there.
me. Dr. Elizabeth Hersack, Navan, Manitoba. I too have been a longtime resident of Springfield, 30 plus years, and have been invested in this various forms of the zoning bylaw for at least a good 5. Question I have, please, is Mr. Doucet's letter was made available on the RM website under the agenda item. Will Mr. Sandhurst's report also be posted or available too?
I'll defer that answer, ma'am, to either Mr. Sandhurst or Mr. Doucet. What is it you're looking for, though, ma'am? Is the report?
His speaking
Just
notes?
basically what Mr. Sandhurst had reported. I did try to write some things down, but it was a lot, and Mr. Doucet's report was pretty much verbatim, so I was just asking if that was also going to be posted. I realize, again, because of the time and the day, that maybe wasn't a caught up item, but perhaps in the coming days, that would be very much appreciated.
Mr. Sandhurst had done some speaking notes. I'm sure they can be posted. I don't.
Thank you, I appreciate that. I've got some questions and some comments as I've been going through the bylaw. I'm trying to do this from a helpful perspective. On page 10 in administration under general definitions, under animal confinement facility, there was just a wording. When it goes into the definition, it says barn, outdoor area, blah, 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 about livestock. It should be livestock are confined. The present typing right now is livestock area confined. So it was just make it better.
Typo. Thank you.
Also on that same page, definition of buffer. There is a mention of objectionable features. I was just wanting to know if that could be defined, because something that's objectionable to one person, you know, the smell of tulips might be objectionable to one person if they're allergic, but not to someone else. So I would appreciate a definition somewhere. On page 20, crematorium, they are describing deceased bodies, and my suggestion would be human or animal. Again, just for consistency, like is mentioned for cemetery on page 24. Let me know when I can continue, I will. On page 22, the definitions for general industrial heavy and general industrial light. Low level of nuisance is described, but not a high level of nuisance. And I was also wanting to know, is this something that is referenced in the RM of Springfield noise bylaw or not? And if possible, could nuisance be defined not only in that definition, but anywhere else it might be in the body of the bylaw? Would be appreciated. And why I'm asking about that is because there certainly are some concerns in the noise bylaw. There may be, you know, this is a difference between someone who might be playing their music a little too loud or having a bonfire and smoke is drifting. I'm more concerned about the 24/7, 365 operations, whether that would be mining, processing, or data centers. So I do feel it's important, and I do feel that we need to tease that out, please. On page 25, what exactly entails a utility center? And where is that permitted? I had a question about that too on page 50, just tying in those things. On page 27, residential related farm. I do feel that that definition is a little sparse, a little brief. And I am going to be providing a presentation further to that. But in the definition, I do feel that they should put in a descriptor defining it as having less than 10 animal units, and also that the site needs to be greater or equal to 5 acres or more. So my request would be to please expand that definition. On pages 29 and 30, talking about zoning districts, in 6.1, residential zoning districts, where you are able to have both equestrian establishments as well as residential farm related. I would also ask if those could be further defined as, again, the less than 10 animal units and the minimum 5-acre site. It would very much help prevent or reduce confusion. And as I said in my presentation, I would go into that in a bit more detail. Page 31, section 6.7, the livestock overlay zoning districts. There are some issues that I have not had a chance to read the second posting by the Municipal and Northern Affairs report. And I understand that this was already an issue. It's brought about some confusion. So I can't comment on the new version, but from what I've read, I do express a request that if it would be possible to clarify that in L4, which in the livestock overlay is livestock prohibited or restricted, pardon me, that equine establishments and residential farm related uses potentially would be allowed, again, based on the size of the lot. And also, if passed, because it's a new item, poultry keeping, and I would tend to not call that poultry keeping, but that's for later. I do find the use, and thank you very much for explaining that for the automotive sales. I did not understand the difference between the primary and accessory use, because when I'm thinking of something that's agricultural, I would defer to that versus having a single home or dwelling and then having those uses associated with that. So for someone who's not familiar and is not living, breathing, planning every day, it is very confusing for a layperson. And I don't know that I would consider myself a layperson because I read. It's not only a door stopper, it's, you know, when you can't sleep at night, you just crack open the development plan or so it's right up there. Okay. On page 10 of the first version of the provincial planning report, it was about section 4.7, agricultural use class definitions, where they talk about specialized agriculture. And this was from Michelle Erb's report, where the comment was, specialized agriculture means the use of land for apiculture, floriculture, horticulture, orchards, similar alternative agricultural activities on a commercial basis and generally requiring a smaller site area. What size would that be? This big, this big, this big? Like some type of definition would be appreciated, again, to try to determine if it would be applicable on a property or not.
What was that for again, ma'am?
Specialized agriculture.
We have a question with the province as well.
I got a whole lot of stuff
What
on that
size
one,
do they want?
Yeah.
Yeah, so we need to have that meeting with municipal relations and Department of Agriculture.
Absolutely. On page 57, table 9.3.
Actually, ma'am, what size would you say is good though?
No, that's not up to her
Well,
to decide.
again, this
It's
is
up to the
this is why you're
province.
deferring to your agricultural planning people.
Okay, no, I'm sorry, I was
And again,
advised.
somebody who might be doing apiculture, that's with your honeybees, wouldn't necessarily require a huge amount of property as compared to someone who's doing orchards.
Yeah.
Right? So it's vague. We just want to kind of tighten things up and we want to make it consistent, not subject to someone's interpretation.
Yeah.
Okay. Again, trying to make it better. Am I okay to continue? Okay, I'm sorry, I was trying to get this submitted, but I couldn't. Page 57, table 9.3, livestock operation use table. I believe that this should reflect and expand on the inclusion of the equestrian establishment as well as the residential related farm as it pertains to L4, because right now L4 is saying livestock prohibited. And it goes into, again, the wording with the province in terms of how livestock is defined. In your bylaw, you have horses are not considered livestock. However, from a provincial legislative perspective, both in terms of disease control, animal products, etc., livestock is what it is. And it's not up to the municipality to make those changes. It's just for consistency's sake. Page 63, 9.24 and 9.25. 9.24 is poultry keeping. And a question I had is, this is a new item, and I understand that it needs to be introduced in the zoning. I'm just I'm not sure that this is the time to be including it. I wanted to ask what the level of interest in poultry keeping has been. Have you had any requirements, like any inquiries through the office or planning or other?
Yes, we have. We've had, I just want to make sure I'm all on here. Yeah, we have requests in the communities, Oakbank, Dugald, in the past, and we've had to shut them down.
And that was my other question. Like, I'll get into that in my presentation, but what you have right now in the zoning bylaw is not sufficient. And I'm saying that both as a large animal veterinarian, as somebody who potentially knows problems and you'd want to nip them in the bud. And you also want to make sure that they are cared for properly and people truly understand that this is a responsibility. This isn't just a passing, romanticized fashion. I'm going to garden, I'm going to can, I'm going to have poultry and, have my own farm eggs. It is a commitment, and there can be a lot of things that can be quite off-putting to some people. So that was my question. Also, there are a lot of municipalities that have also had to address this issue as well, but I will table that until my presentation because I'd like to keep going. I also had wanted to know is, as I had suggested in table 9-3, if 10-1, residential mixed zoning district dimensional standards, if that also could take into account the acreage size, etc., for operations such as the equestrian establishment and residential related farm usages. Next point is 9.16, animal lodging. I had wanted to know, there did not seem to be a provision to deal with any remains or if any animals were to die during the time that they are there, because they're not necessarily belong to the people that own them. And had also wanted to ask if the waste management policy that is associated with that category of use, if that potentially could be included in the poultry or backyard hen is what I would probably more appropriately call it, but something like that. Your manure management tends to cover livestock. Poultry technically is livestock, but in this particular application, it's a little bit different. You might want to defer more to the Animal Care Act in terms of how animals are raised and handled and cared for. So those were just my my questions or opportunities. As I said, it was just more to try to, I had some questions, I had a little bit of confusion and just trying to button things up. Thank you.
Thank you, ma'am. And who else was next? I kind of lost track there.
Excuse me, Elizabeth, can I get a copy of your report? Do you have copies? Can you email it to me? Thank you.
We're still on inquiries then, if Pat?
Okay. Pat Burbank, Sunnyside. Before I start though, I just wanted to mention or ask, is somebody recording all these questions? Because those questions Dr. Elizabeth mentioned were incredible. I know you're making a recording of the meeting, but is somebody noting these questions?
Yep, yep.
Oh, very good. Awesome.
There's
And then how are they going to be addressed? Are you going to answer those questions? Are you going to post them on the website for other people to see?
We're going to take all the information in. We're going to have discussions with council.
Okay,
Thank you.
okay. So we don't really know if people are going to get their answers then?
It will all be done through a future public hearing, and the information will be brought back and presented to council.
Okay.
Yeah.
What did you say?
All the information will come back at a future public hearing, so everyone will hear the answers as they're provided to council.
So there will be another public hearing.
That's our understanding. I can't imagine we're gonna get through everything tonight, so
So is that public hearing?
Okay.
that'll be a council decision.
Thank you.
Okay, so my question, it sounds pretty weak compared to Elizabeth, but I'm gonna say it anyway. For a zoning bylaw that will impact so many things, there seems to be a lot of rules, etc., regarding signage. In my opinion, that is one of the more minor issues in a zoning bylaw that could negatively, that could have a negative impact on property values, employment of your property, or pardon me, enjoyment of your property and surroundings, as well as the entitlement of use of your property. There are 4 pages of rules just for signs. It just makes it very complicated to understand all this. Section 9.27.1 states, no person shall erect a sign without first obtaining a development permit, unless otherwise specific herein, and no development permit to erect a sign shall be issued unless all the sign regulations and yard requirements of the bylaw have been satisfied. This seems excessive for a number of signs that I can think of. For example, the Cooks Creek Pancake Breakfast, promoting the hockey and baseball games, chicken days, etc. There is a reference in section 9.27.13b that says all temporary signs shall be removed within 7 days after the date of the advertised community event or at the discretion of the designated officer. So my one question is, why wouldn't the bylaw define what signage requires a development permit and which signs don't? Seems to me that every sign requiring a development permit would waste a lot of time. Thinking of chicken days, can you describe how those signs would be affected by this bylaw? Is there a development permit for fee for signs, and what is it? And finally, election signs or yard sale signs, for example, do they require a development permit? Is there a limit to the number of signs? Wouldn't they be considered temporary? And it, believe me, is confusing because even with the election now, I know Councillor Kuczynski is getting complaints about where his signs are. It's like, it's not straightforward. So, and that's 0801. So, thank you.
Thank you. Much of those signs are on highway access, and that's a highway department that has issue over that, a domain over that, and Chicken Days was one of those situations. Okay, Jill, were you up?
You're the answer to Pat's question, though. You had a particular question. Chicken Days is a town.
Go ahead. Do you want to answer them?
How do you know that those complaints are from highway department? When I inquire our election official, he couldn't tell who it is. He said it's a privacy act, so he cannot tell you. How did you get that information?
What information?
And he didn't release that information to me.
About Chicken Days?
No.
About what?
My sign on the highway for the election.
Well, I don't know. That's
So
highways.
you just make statement that it's Department of Highway. How do you know it's Department of Highway when I cannot get that information? Who made complaint about my
So
sign?
I think the general statement was that election signs that are on a highway, provincial highway, fall under the highways policy.
That's not what I asked, Mr. Mayor. Please don't interrupt.
Well, I think the question of Ms. Burbank was,
No,
where do election signs fall? They fall under highways if they're on the highway right away. And they're considered temporary signs, the same as Chicken Days along the highway. They're considered temporary and they have strict rules they have to follow through the highways department.
That's not my question to Mayor. My question to Mayor, how he knows who complains when I couldn't get this answer to complaint, who complained about my sign.
I have no idea who complained. Why would I know that?
Well, you just stated it, Department of Highways.
Was their jurisdiction? That's all I said. I don't know who made your complaint about your signs.
Well, you know that people complaining about signs, it's Department of Highways. And when I asked this question to our, official of that's supposed to run the thing, that he doesn't have answer for me. He said he's going to look into it.
Okay, well, I can't answer for him.
Okay. Thank you.
You were next, Jill.
Jill Overall, Oak Bank. And I have to say before I start with my questions, that this is a great opportunity. I know you were ordered to do this by the municipal board, but when you come here and we've got experts like Elizabeth telling you little parts of your bylaw that are inadequate and you can add to it, it's a golden opportunity. I mean, everybody wants to make the world a little bit better, and I'm sure every council wants to make their bylaws a little bit better. So I hope you're really listening to that. Okay, my first question is, were all councillors able to take part in workshops regarding 2609? Have you all gone line by line at all?
Well,
that's a no.
Are you saying no, you Councillors Miller and Kaczynski? Well, we have. We went through 2125, the zoning bylaw. The changeover from 2609 is simply the bylaw to change the number. That's all it is. It's a one. It's a one page. But it's a.
Doucet actually.
No, you're addressing me, ma'am. But I'm still talking. But nothing changed. 2125, and we have all been through this. So I don't know why.
There were many changes to 2609 that were not in 2125.
Well,
and I'm wondering if all council were able to go through all those changes line by line.
I've gone through it. They're the new 2609, which is essentially the same. Pardon me?
Can we poll all the councillors to see if they have?
Well, I'll let them speak for themselves if they like. But yes, we've gone through the 2125. The change into 2609 is simply a paper changeover to make it more, not as confusing to people.
Okay, but I'm sorry, I don't remember his name. Mr. Sandhurst created 2609, is what you said. He wrote it. And I'm wondering if the councillors got a chance to go through all the changes with Mr. Sandhurst to make sure they're what councillors wanted and what the residents wanted. Do we just assume that Mr. Sandhurst did it all right? I know that's his job, but do we double check before we make such a big?
I don't know, council want to answer that? Councillor Kaczynski, you had your hand up?
Thank you. I would say we did not go through with the 2609. We didn't have time, and we never even knew it that the 2609 we're gonna be voting on it. That's gonna be new number. We just announced 3 days before the next council meeting, and then was the first reading done it, but voted by council, but we never participate in 2609. We wasn't even asked as a councillors if we want to have 2609 being put as a new number for the zoning bylaw.
So, Mr. Mayor, is it a normal situation to not have council go through a new bylaw, like a land use bylaw?
Well, there's a difference in that we have gone through 2125. It's essentially the same as 2609.
Yeah, I'm gonna leave it at that.
So I
but
want to
I-
add that, so administration and planning staff met with council on June 15th. Bylaw 2609 was presented to all of council with key features table showing the changes from 2125 to 2609. They were given that draft an opportunity to ask questions. I don't believe anyone came to me with questions. I believe some councillors did go to planning to clarify things. And we did talk about the process going forward with the new number and how that would be rolled out.
And all of council understood that there. So I remember things differently. I can't speak for councillors Miller or Kaczynski. Okay, ma'am.
Okay. So my questions are related to commercial composting. So Mr. Doucet, if you're looking for that, it is in section 9.10, commercial composting.
Sorry, ma'am. What was the section you were saying?
Commercial composting. It's under section 9.10. And I've stood in front of council before, as did a couple residents on Highway 207 that had an issue with a composting facility beside them. So this is an issue that's probably pretty familiar to you and me. So if an application for a commercial composting facility is made, it would require a conditional use hearing. Is that correct? Okay, so along 207. Just the example that I have that we've all discussed. So while you're looking, so for people's information, this is what happened. A conditional use hearing was held and council passed a resolution approving a conditional use permit. The conditions in that order were not enforced, in my opinion, and they were not met. So can this bylaw under commercial composting be made more stringent so that we don't have problems with enforcement? I do have, I have information that might make more sense to that question, because currently in your commercial composting, there are only 2 regulations. And I have a suggestion for 5 additional regulations that would make it a little more tight so that it wouldn't affect families. Because we know that the problem that we had with commercial composting resulted in a lot of rats, flies, horrible smell to a lot of people living along 207. So my question is, can this bylaw on commercial composting be made more stringent? Can we give it more teeth?
Have you got the 5 there, ma'am, with you? 5 additionals?
Do you want me to just read my info?
If you got time.
Oh, I got
Or you can submit that to us, and I'd like to
I
know what
will
the
submit
5
that
are.
to you, but I'd like people to hear it. I mean, this affected
Go ahead.
family
Yeah.
greatly. Okay. Well, this is my info. I'm here tonight to tell you I stand against the proposed bylaw 2609 as it's written currently for the following reasons. The bylaw does not address known concerns regarding commercial composting operations. In the bylaw, commercial composting facility is listed on table 9.1 under industrial class / type. It's a conditional use in the MG, AG, and AR zones. In section 9.10, commercial composting facility reads, composting for commercial purposes in ag zoning districts must comply with the following regulations. And it only lists 2 regulations. One about complying with the Waste Management Facilities Regulation, MR 37/2016, as well as other provincial regulations. And then a second regulation which states that initial decomposition of compostable waste for operations within 1,500 feet of a residence must be contained in a vessel or on a site from which potential odors can be mitigated. None of that happened. This bylaw fails to include a number of conditions that the municipality should be responsible for. It does not reference boundary or setback restrictions from neighboring properties, nor control of runoff, nor setting of drainage conditions, nor compliance with lot grading bylaw. Bylaw 0801 had a regulation, which was 38.9, that states council may require a detailed engineering study from the applicant, certifying that the proposed composting operation meets or exceeds all applicable provincial regulations. So we, both you council and I, and the residents along 207, we've learned through recent experience that this type of use can be a huge nuisance to the neighboring properties. We've all learned, both council and the neighbors of one local composting business, that rodents, bugs, runoff contamination, and intolerable odor are just a few of the issues that have occurred in Springfield. So this is an opportune time to make sure we tighten up composting regulations. Bylaw 2609 gives the municipality the ability to regulate many aspects of construction and land use activity in Springfield. If you take the time to listen to resident concerns and suggestions in this public hearing, then this is a golden opportunity to improve our land use planning by implementing resident suggestions to our zoning bylaw. At the very least, I hope all of council gets the opportunity to discuss our suggestions together and see which, if not all, of these suggestions you will implement. It just makes sense that the many hundreds of residents who actually live or work throughout the municipality will notice areas of the bylaw that need attention. Just like Elizabeth. I mean, nobody else thought of those. We can't expect just the 5 of you to understand all the needs of all the residents without hearing from us. In my opinion, as this bylaw stands right now, it's actually weaker than bylaw 0801. Every council hopes to have an impact and to leave a municipality stronger than it was when they found it. And I believe that you, our council, should take this opportunity to make this land use zoning bylaw stronger. To that end, I believe bylaw 2609, clause 9.10, should be expanded to include 1, that a detailed engineering study be first obtained by the applicant, certifying that the proposed composting operation meets or exceeds all applicable provincial regulations. 2, restrictions as to setbacks from neighboring property boundaries should be included. Also included should be compliance with all other related municipal bylaws, including but not limited to drainage, enforcement, lot grading, and fencing. Number 4, include compliance with all conditions set by council at a conditional use hearing. And number 5, added wording to ensure that the conditional use permit shall be revoked if all conditions under which the permit was originally issued are no longer met. So I hope council recognizes that this is such a great opportunity to improve this part of our bylaw. When you have hundreds of people showing up with concerns and new suggestions from throughout the municipality, you know that you should take the opportunity to make things better than you found them. Thank you.
Thank you, ma'am. Then we can proceed on to those in favor.
There's more questions.
Oh, okay, sorry, I didn't, did you have your hand up, Mrs. White? Okay, then, yeah, you're, Tanja, I think you were first, go ahead.
Carolyn White, Sunnyside. Under residential use class definitions is something called a planned unit development. I read that it means a development planned as an entity in accordance with a unitary site plan, which permits flexibility in siting of buildings, mix of residential uses and housing types, usable open spaces, and the presentation of significant natural features. On table 9.1 of the proposed bylaw, planned unit developments can happen in different residential classifications, like RS, which means residential single unit, RT, residential 2-unit, RM, residential multi-unit, and HA Hamlet districts. Thank goodness that planned unit development use has been changed from permitted to conditional use since the unsuccessful zoning bylaw 2125. So that's a good thing. But there's still some concerns. So under part 9, use standards, there are 8 conditions. And the first one reads, planned unit developments should be consistent with the desired character for the areas as set out in the development plan and any applicable secondary plan. And since coming here tonight, I've heard that twice. So Mr. Doucet said that the new bylaw has to be
Consistent.
consistent, thank you, with our development plan, Springfield development plan. And Mr. Sandhurst also listed it as his number 1 point that he made. So my question, sorry? Number 1, yeah. So my question is discussion or citing of a planned use unit development in our Springfield development plan?
In our development plan? Yes, there's a residential component to that. There's
So that
several
talks
components.
about planned unit development, that defines it and talks about it. I'm just curious where it is. I can't really find it.
I don't know. I'd have to get I'll ask.
We'll research that.
Yeah, we can research
I don't
that.
have it on hand right now.
Research it? Okay, I think it's a pretty big, important point. Planned unit developments are, yeah, they're pretty big. Can I get someone to tell me what a planned unit development is and how it is different from a sector plan or a secondary plan? Do any of the councillors know that?
Deputy Mayor.
So a secondary plan is an area, a fairly big area. And the unit plan is more concise to a certain defined area. So you're talking in a smaller space. And then the secondary plan is more of a bigger space.
Okay. And I'd like to know how residents are going to be benefiting from introducing planned unit developments. I know developers might be, but I'm wondering what the benefits to residents are particularly.
Planned unit developments.
Yes.
I'll have to defer that to our planning department.
So I'd like to hear that maybe now from the planning department.
With the plan unit development, can you hear me?
Not really.
No, okay. With a plan unit development, it looks at a specific site area. And it could, through a conditional use, look at different configurations of properties. So if you have a density, say of 40 acres, and each lot is to be 5 acres, maximum density would be 8 units at 5 acres. With a plan unit development, you would have a total of 8 units, but maybe council can reduce the size of those lots so you're having less roads to maintain, tighter densities to preserve a forested area. So it's a very specific type of development. In the last 25 years, we have not had any applications for such a thing, but it is an option.
So
Mr.
my question
Mr.
is, what are
Sandhurst,
the
unless there's
benefits
anything
to
more.
residents of having planned unit developments?
Oh, yeah. Sorry, I didn't hear your
So
question.
my question is, what is the, like, we're introducing planned unit development in the bylaw
It was already there in 0801.
in 0801?
Yep.
Okay, so for the new 2609, I'm just wondering if a review and a report from the province is required.
Likely because there'll be a new application for a subdivision.
Okay. Is it a
Or
rezoning or a conditional use?
Be a conditional use depending if it complies with the section of that zoning bylaw.
Okay, so the conditional use would require a review and report from province.
A review and report from to council for conditional use. A subdivision is filed with the province.
Okay. Thank you very much.
I'm going to give my seat up. I'm going to go out there. Do we know how many people have presentations and want to come in?
That's what I'm just about to, I wrote that down. We're going to go with Mrs. Bell there, and then they're going to ask people in there if they've got inquiries as well. Actually, Mrs. Overall, if you're going out there, ask them who wants to talk about inquiries.
So I actually now have 2 questions. I won't be available for quite some time the second unless I can speak tonight, present tonight. When are the other, you don't have to give me the exact date, but within a week or next week or 3 weeks, by the time I think everybody gets together and converses with the government, when exactly would we be expecting these other open houses or public hearings? Sorry.
By the end of tonight, we'll have an idea.
Okay, so let's say that we extend by tonight and there are approximately another, I would say 40 people or 30 people that need to speak. How would they be scheduled in next week? Or 2 weeks from now?
We'll have a date and time before we can adjourn. We have to let the public
Why I'm
know.
asking is this is in prime time, a very, very busy season, vacation
For all of us.
season. A lot of people here won't be available. I know I won't be available until next September, this September coming up. So I hope that people can be accommodated some way, but I'll get to my other question here. We have 746, so section 4, section 746. I'm sorry, I don't have the page here. What it states is that when development is proposed in suspected hazard areas, the applicant may be required to complete professional environmental, geotechnical, or hydrogeological studies that would provide recommendations on preventative and mitigation measures to eliminate or reduce the risk. Can somebody tell me what are or where are the protocols for determining which study is used in this, since the verb or conjunctive or is used?
I can tell you we've had the subdivisions there where there was inland that was prone to water. I forget what the exact term. Most of this can be validated by our Mr. Doucet there. But we've asked for all the studies for the zones. They've come through with all the engineering studies. And I can't really say the name. I think they're selling lots now. But that would be near Lauren Hill and 207.
Okay, again, the hazard lands aren't defined. They're not identified in the area. And again, it's saying here, environmental, geotechnical, or hydrogeological studies. What determines which study is to be used? I can't find any protocols in 2609. Could somebody, perhaps then, if they aren't in there, perhaps more detail, more less subjectivity, or we put in the word "and" so that we cover it entirely, and there's more of a study on the proper, including it. Like, I'm not sure if hydraulic conductivity of the soil is included in hazard lands.
I'm not sure what that is, ma'am, to be honest with you there, and that's what planning
Exactly.
and we have experts for that there, but that example covered all those bases there. They had to satisfy environment there. Environment was a part of that process. These bylaws there, much of it will refer to provincial laws dictating what that is. If it's a low water table, it's ground under direct, I forget what it's called, Goody or something like that. But all that is done by the experts there that know the those processes there. So we refer to provincial agencies as well as part of that discussions there
So
to
all
ensure that everything's
development-
done correctly.
All development on hazard lands goes to the province, goes to ECC?
Yeah, they're always advised there, and then they'll advise us there if there's any issues with regards. There's certain I don't know what the number is. They'll read it and ask and tell us that we've got a problem with this. There was a subdivision out north here where the person had got the problem, got the 3 lots subdivided there. And the environment noticed that there was a pond, I guess, or whatever it is. Again, I'm not an expert at that. And they said that had to be preserved and could not be built on or extended to. So the province has experts with regards to that.
Yeah, there's drainage and such of the soils in that wetlands, but we're not privy to that information.
Who's we?
The people, us.
Well, yeah, but no,
And so when these things do go to that,
there's
what I'm
public
saying
hearings.
is under here, it's very vague. We don't know what is going to be implemented. Environmental, geotechnical, or hydrogeological. I would just like to see some more definition, more detail, more protocol, so that I know that individuals, when they do vote, council members vote on a certain development, that they're more comfortable, that they're well informed in what they're doing.
Yeah, and we adhere to that. All the neighbors are advised of that. We don't advise the entire RM. That's impossible to do. And council is elected in their areas, so everybody is aware of it. So we represent the 17,000 people
I understand.
there. But I understand your question, and the province is an oversight on that. They made sure, because and no disrespect to planning there, but it was noted on the planning there, the conceptual plan there. And the developer that came in there, it's the owner that wanted to subdivide it. There was a low-lying area there, which mean nothing to me, of course, there. But the province came in there and says, well, that is an area that has to be conserved because it feeds into the aquifer there. So the province came up and saying, you can do lots 1, 2, but lot 3 cannot be built on this corner, taking away 3 or 4 acres.
Okay. And how
So sorry, Mrs. Bell, the other lot that it came on there was also affected, and that person was made aware there, but they kept it pristine. They liked the natural, which I like the idea that the ducks are out there and so on. So they were aware of that, and they could never build, and they never wanted to. But still, that land next door, they weren't aware of that. Everybody's aware now.
Okay, thank you.
Thank you, ma'am. Rod, you can sit right here.
Helen Garrett, excuse me, I live near Birds Hill Park. I have a couple of questions. The current zoning bylaw 0801 of the RM of Springfield is a tool meant to guide the municipal council to implement the objectives and policies in the development plan and the 2 secondary plans. The objective is to set specific rules and guidelines excuse me, for development and land use in municipality. The guidelines are meant to regulate the use, size, height, and location of buildings constructed on properties within Springfield to be consistent with the prescribed zoning districts. My question is it correct to say that these rules are to be enforceable and must govern the use of land and buildings and the location and form of those buildings?
Yes, everything's enforceable. We got our community safety officer who also does our bylaws, and they will follow up with any violations or reports of violations. And if they're concerned, planning or whoever is involved as part of the RM, the CSO can be advised as well and can follow up.
Further to that, my second question. This, well, your answer implies that some level of enforcement is required to ensure adherence to the bylaw. Who is responsible for enforcement, and where is this stated in bylaw 2609?
It's our CSO officer that's responsible for bylaws. There's many times where you can't have everything in the bylaws there. Who's going to follow up? That's getting into extreme finite details. Our bylaw is enforceable by our CSO officer.
But who would you propose could actually go out to a site and investigate it and report back?
Yes.
Our inspectors can do that. I'll defer to Councillor Doucet or Mr. Doucet.
Thank you. Wow, I moved up. With the zoning bylaw, there's many aspects of it. There's zoning setbacks, there's land use. So there's many staff who look after enforcement. Could be our building inspectors, could be our survey crew who look after things, could be a development officer, depending on land use. We get our CSO involved. So there's a number of factors where enforcement comes into play, depending if a building permit is submitted and doesn't meet the correct setbacks. There's two options. It gets denied or it goes for a variance before council and if it's conditional use, it goes before council for a hearing. As the previous lady had come in about the compost. The application was not for a compost facility. The application was for a general contractor who wanted to have compost as part of his business. So two different things from a commercial compost than a home-based business.
So you're saying this is specified in the new zoning bylaw? Because I didn't
The
see any
bylaw
real,
says designated officer.
but I didn't see
and
any
there's
real references to enforcement and how it would come about.
we have an enforcement bylaw, I believe, Colleen, and then we have designated officer bylaw, so it could be different staff. So,
That's it.
yep.
Okay, thank you.
Thank you, ma'am. We're still on inquiries there, Councillor. I'm just joking with you.
Okay, Sue Zemsky, 15 Layden Crescent. For my own small part in pointing out what I think is an omission, I wanted to bring your attention to the fact that there are no references at all to condominium buildings or condominium projects in this version of the zoning bylaw. There are standards set for secondary suites. There are quite extensive standards for those. So why are there not any for condominiums, Bearlands condos, etc.? There is reference only to the Condominium Act, but that act is also not included in this version of the zoning bylaw. The existing bylaw 0801 covered the definition of condominium meaning individual ownership of a unit in a multi-unit structure where expenses common to all parties are shared. Condominium bare land unit meant that a unit of land is defined by delineation of its horizontal boundaries without reference to any buildings on the condominium plan. And then there's the condominium unit that meant a part of the land or building that is designated as a unit by the condominium plan, as is comprised of the space enclosed by its boundaries and all material parts of the land within this space at the time the condominium declaration and the plan are registered. None of this is included in 2609 zoning bylaw version. And one further item, my own personal beef in a way, there's no references to Airbnbs nor verbos that are increasingly being used in the RM of Springfield. They require rules and regulations for the sake of the people living in the vicinity of these rentals, the owners, and such lease space and the tenants that they lease them to. So that's it.
I thought there was, ma'am. I thought there was B&B as part of that. I'll be hard pressed to find that.
Airbnb. Those are those, yeah, quick rentals where you can just take over the place and the owners aren't around.
Okay, and
Whereas the other ones,
the condominiums, I know you're quite good at that. That's part of your forte.
yeah.
But that's good. We'll take that under advisement.
Oh, well, he's going to. They're going to get that in there.
Thank you, ma'am. Ma'am?
Susanna Zanell from Nevin. I just have a very simple question. With all the suggestions that are being made and changes that have been made from the original documents from 0801, is it possible for you to post online a red line document so that you can actually easily see the changes that are either already made or that are going to be made based on the suggestions that you're receiving?
Good question, ma'am. I'll pass that off to administration, either the CEO or Mr. Doucet.
So we did not prepare a red line document, but we did prepare that key features table that outlines the changes that are specific from 2125 to 2609.
You understand that, ma'am?
I understand it.
I understand that, but a red line document is much easier to read than a table, because to read a table, you have to go back and see the original document, the document you have now, compare them side by side. A red line document is you can actually see the changes as they're being made. And I would suggest that any changes that are made moving forward, based on the feedback you're receiving now, maybe are done in a different color so that we can actually identify what is now being changed moving forward.
So I think
From tonight's meeting, we would be tracking the changes made to 2609 based on all the suggestions and comments we're hearing. And obviously from the provincial report has requested a lot of changes. So we would be noting that change going forward.
Susanna Zanell.
Thank you.
Okay. I think we've got everybody for inquiries. I think Mrs. Aikens was next. Then you're next, Rod.
Margaret Marion Aikens, Springfield. Okay, first of all, this goes right back to the beginning of the meeting. who removed the aggregate bylaw portion? And why was it removed? And you, Mr. Mayor, said that the province was in and could answer that question.
Well, I never said that. CEO did.
Oh, the CAO did, okay.
Yeah, I thought they were leaving early.
Oh, somebody's here, she's got her hand up.
Okay. Okay, is there another question?
Could you come forward and
Excuse
so
me.
all of us could hear?
Excuse me. I'll say that, but is there another question? No? She's pregnant, if I understand. I've been wrong before, so I hope I'm
Well,
right.
can we not get an answer to my question? Since we've got
Sure,
people
if you
here?
want to answer that, ma'am, now. If you can come up. Thank God you're pregnant, ma'am. I made that mistake in Little Grand when I was up there.
It's past the phase where it's questionable, I think.
If you want to sit down, obviously we'll make.
I'm okay. No changes have been made to this bylaw. The change in our planning report changed very minor wording from aggregate and mineral operation to aggregate operation. It was a requirement based on a previous circulation. We followed up with the department of mines. And they revised it to be not a requirement anymore. There's been no change to the bylaw. It wouldn't have any implications for the bylaw. It was related to provincial alignment with provincial wording that's not relevant anymore.
Okay, thank you. Okay. Second, in the chronological review, Mr. Doucet, that you gave, according to the, you didn't make mention that according to the provincial review, that the requirements were, there's 13 now, I believe, with the second revision, requirements that must be implemented and that second reading cannot proceed until those requirements are in the document. Is that not my understanding? So we definitely, because they weren't done this evening, we definitely have to have a second public hearing?
Not necessarily a second public hearing. Council can pass items.
A second public hearing was never asked for in that report. They made recommendations to make some text changes. And if council agrees to adopt those changes, they could include it in a resolution prior to giving it second reading. If council adopts them after granting second reading, then a second public hearing is required.
Is required.
Does that make sense? Does that make sense?
Well,
If council changes the text after giving second reading, then you have to have a second public hearing. If council changes the text before second reading, a second public hearing is not required under the act.
Okay.
That's
okay. Fine. So
I didn't write that
when are those changes going to be made? By the time you do the next red line copy, those changes from the province will all be put in?
We'll have to have discussions with the province to see what
in
exact
the report,
wording.
it says there's 14 mandatory. Well, no, it's changed now.
13 or 14. Yeah, I just received the report at 3:30. I'd have to review the text document.
Well, even in the first provincial report, it was 14. Now in the second one, it's only 13. But it did state that they must be.
They stated that if council proceeded without making changes, it would be forced to the minister to make a ruling and possible municipal board hearing.
Yes.
That's what it said.
So are those changes going to, are those changes you're going to include them?
I don't decide that. That's a council decision. If council wants to include it in their bylaw.
Okay. So council, can I have a question, Mr. Mayor? Would you ask council, are they have they reviewed the provincial report and are they willing to implement the required 14 changes? And the 22, well, now 25 recommendations that the province has put forward?
I'll speak for myself, and if council wants to. I've looked at all that, and we'll have to wait and see what the province, this is still a live document per se. We'll see if what happens in the next, I don't know what time frame we're looking at for the next public hearing there, if there's other changes there. But my opinion is I am waiting for everybody's talk here before I make a decision on that.
Okay.
Anybody else want to speak to that? Councilmember Fuel?
I reviewed the first document. I have not reviewed the second document that was just sent out. But with the recommendations of the report, I have no problem with those ones that are required.
Good.
But that could change. So that's the whole idea. We'll see what changes are. But Councilor Kaczynski?
Yes, I didn't see the new one. Yes, I just look one that aggregate was removed, but we have to review it and compare what was said in the first one report and second report, and then we, I guess, have to have discussion about it as a council and make the recommendation to administration. Thank you.
Councilor Miller?
Thank you, Mr. Mayor. I echo what Councilor Kaczynski says, that definitely we have to look at sober second thought to make sure we're comfortable and that the people in our community are comfortable with with those recommendations and so forth. So this is a process that's going to take some time. We got to do it properly and be precise and be accurate, and it has to be receptive to the public. So I'm more than willing to give time and effort into this, not just ram it through.
Good.
I think I answered that before, but we are still looking at all this and we still have conversations to have. So
Okay.
nothing is going to get rushed
Well,
through.
I'm glad you said that, Melinda, because apparently to date, council has not gotten together and gone through the changes. So it's very imperative that a document of this importance is reviewed by council, all of council.
I agree with you, ma'am. And I had an issue with regards to minerals there, and the provincial delegate there, sorry, I forgot your name, ma'am, Holly, basically answered that. So it's a process, a living document, and it's up to change, and we'll see what those changes might be going forward.
Okay, and just for clarification, I'd like to know what, this question is directed at Mr. Sandhurst. What community engagement has occurred with 2609 with the public? There hasn't been any.
I'll agree to that, but typically, you have to answer questions after the check.
Okay, so you are the employee applicant, correct?
I'm acting as the applicant on behalf of the municipality in dealing with draft zoning bylaw 2609.
Okay, but you're employed by the employer. Okay, so then why wasn't your submission posted online? Because you would have had it well in advance.
Sorry, my submission.
Well, your presentation that you gave to us.
So I think we clarified that those were just a speaking note, so we will get those transcribed and post those on the agenda.
Okay. Okay, now some other direct questions in regards to the zoning bylaw. With respect to the development permits conditions, especially when in the zoning bylaw, on several occasions, it says that it could be up to the designated officer or council. So who determines if it's council or the designated officer who issues permits? How is that determined? It doesn't say, it just says one or the other could do it. But what are under what circumstances would it be done? Like who would you choose? Flip a coin?
Which section are you referring to?
Section 2.5.
Through the whole document.
And it's through the whole document, actually. In several other locations. If conditions are set by the development officer and not council, how is the document followed?
So a condition attached to a development permit. The designated officer or council shall impose with respect to a permitted use such conditions to ensure compliance with the bylaw. So if it's a permitted use, an application does not have to go to council, but myself as a designated officer can impose conditions on that specific property. Conditions like a hydrogeotechnical analysis. If it's a flood prone area, it's still a conditional use. So it's like an and/or situation depending on the circumstance.
Well,
we have the West Pine Ridge area that is a subdivision, goes before council. They have to provide a geotechnical analysis, but that is voted upon by council because it's a subdivision.
Well, because it's a water sensitive area.
That's correct.
That is a requirement.
Of the secondary plan. So therefore, that scenario is a decision of council. If there's a house wanting to go beside the Broken Head River Creek, house is a permitted use, I can ask for a geotechnical analysis to make sure that house doesn't fall into the creek. Those are some of the conditions I look at.
Okay, so it's not a conditional use where
It's not a conditional use at all.
No.
It's conditions placed on a development permit.
Okay. Okay. So when conditions of a development permit require a development agreement, and when they are required, and what is the process for preparing them?
Which one are you referencing?
I'm referencing development agreements.
Okay.
So I want to know what the process is of development agreements, what they are.
A development agreement can be placed on by a rezoning, which is council.
Correct.
A development agreement can be placed on a subdivision. And it could be placed on a conditional use or variance. Those are all council decisions.
And are they
the development agreements are drafted up, and the mayor and CAO have the authority to sign them.
Okay, so the development agreements will be public?
Development agreements are never public because
Okay,
it's a private document, a legal document with the municipality and the developer. The only time it becomes legal is when it gets registered at land titles.
Okay, so are you still going to be having development agreements attached to titles?
Yes. That's a common clause within the
so they don't become public until they are attached to
because it's a negotiation and it's legal.
Okay. Okay, that's my questions.
Thank you. And we'll wrap it up with Rod.
Good evening, Rod Fraser, Dugald. Great question so far today. Very much appreciate it. I'm going to throw a couple little softballs at you guys. When I'm looking at the table 10.1, you have different minimum widths for your residential, single residential, 2 residential, and then multi-residential. Why is it that we've gone, used to be 65 feet was the minimum. Now we've gone down to 50 feet for single. And then the 2 residential, we're at 75. And then you look at townhouses, we're at 30. And multi-unit, it's 30.5 feet. sorry, it's all in feet, the numbers I'm giving you. Why can't it be consistent? Like, we seem to be shrinking and playing with the lot sizes to help different developers in that. That's something that I've really noticed. Should it not be a consistent, if it's two residential buildings going there, like a side by side, should 30 and 30? If it's a townhouse, each one of those should be 30 for your minimum width?
Well, we get many developers that come in after the fact and looking for widths, typically to be reduced to accommodate. They may change it from a single family house to a side by side. I'm not sure what they duplex there. So we look at the zoning and the district dimension standards there, and it's up to council to approve that. We've had many in the new wheatland. I think it is the wheatland area there, and they've decided to go a little bit more to side by sides in that one area when it was going to be single family houses, and we approve it or we don't.
Yeah, I understand that. But I moved to Springfield to be part of Springfield and a rural area, have open lots. And then as soon as I come here, I'm seeing council say, yes, let's shrink down the lots because the developer wants to put an extra 2 or 3 houses there. Right? That's great. You guys are shrinking down lots for the developer, not for the people that have already bought their lots. That, I don't see that being very fair. So that was my first question. Second question, when I was looking on your agenda, the only letter that you got that says that, yeah, this is a good bylaw, we agree with it, was the RM attaché. Why is RM attaché reaching out to us saying that's a great bylaw?
Because we send it out to other RMs that are around us there, and they can either make a comment there. Some don't. Others will make comments there, and that was their comment. I can't speak on their behalf, if that's right.
Rod, I'd like to clarify that. Dan here.
No problem.
Under the Planning Act, we must submit notification to the surrounding planning districts and municipalities. Their report never said they had no, their report said they had no concerns with it.
Yes.
There's no direct impact to them.
Yeah.
They didn't say it was a great bylaw. They didn't say it was a bad bylaw.
Okay, sorry, I
Nope.
misspoke, but
I just wanted to
just generally,
clarify.
right, they said, hey, we're fine with it.
There's no concerns because it had no direct impact on them.
No.
And we haven't received any correspondence from any of the other surrounding municipalities.
Okay, well, thank you very much. I hope that at our next meeting that we're gonna have for this, we could have it in a little bit of a bigger venue, would be very nice. And on a side note, I agree this is a living document, but it's very disheartening to see that the people at the front here, I think there's only been one person that maybe has read it all. So when you say this is a living document, I think we're still in labor right now. So maybe we should have held off until we had all the information before we have a meeting. But thank you very much. Have a good night.
Thank you. Did council want a couple of Mrs. Nyland?
I wasn't going to speak, but I want a point of clarification tonight. So, Janet Nyland, I'm just reading from the report from the province that was came in late tonight. And then I heard what was said, and I just want clarification before I leave the room. It on the second page, third paragraph up, it reads, all required changes identified in the attached table must be incorporated into the bylaw prior to second reading. If the required revisions are made in advance of the public hearing scheduled for July 27th,
2026, and presented as part of the bylaw at the hearing, a second public hearing would not be required. So that's where we are tonight. If a council wishes to receive public input on the current draft and make revisions afterwards, a second public hearing will be required once these revisions have been made. So am I not reading that we're going to have a second you can continue this public hearing, but then you're going to have a second public hearing showing us all the revisions?
No.
Yes.
That's what it sounds.
That's like
Do you wanna-
Well, we got the
Okay.
comments down here.
Hi.
Just state your name, ma'am, just for people that are listening.
Sorry, my name's Holly Ricknote. I'm the acting manager for the Beausejour Provincial Community Planning Services Office. So the option that I outlined is standard process. If the hearing is adjourned and continued, as long as the items are gone through in the hearing and the public has an opportunity to make their presentations based on the changes that have been outlined, and as long as council passes a resolution that outlines the changes that will be made at the public hearing after receiving public presentations, that would satisfy our requirements.
Thank you, ma'am.
So just to remind council, the first time we went to the municipal board and there was a difference between minor changes and substantive changes. And so am I assuming that none of these changes are substantive from the province? But you might have substantive ones from the public, like through this hearing. Is that would require a second public hearing?
So as long as we're still within the hearing, council can discuss those changes and make those changes before they close the public hearing and include those on the second reading resolution. That would not require a second public hearing. If they were to close the hearing, give second reading, and then make further amendments, that would require a second public hearing.
And this is where we were before,
No.
where it was, if there's a map change or a substantive change, and I think it was the planner from WSP
Yeah.
that.
And those changes were made after the public hearing.
Was closed.
And that's why they said we should have had another second public hearing. So that happened after the public hearing was closed, council gave second reading and made changes.
Okay, I'm going to disagree with that. Colleen, I hope you get a legal opinion though, because if there's a map change, let's just use that example. That might change something that impacts somebody that didn't know that that change was being made at second reading. And so what I understood was you wouldn't necessarily give second reading, but you would have to have another public hearing process advertising those changes. Those
Yeah, and I think,
ones.
you know, we can clarify, but that was definitely after second reading. We're still before second reading, so we can discuss those changes and have the public understand those changes and present on them before we close the public hearing.
You're not catching what I'm saying.
No,
I
yeah.
agree with you that you wouldn't give second reading. That's where we got messed up before, because we had given second reading. But if you're making a substantive change, I do think you have to re-advertise another public hearing. I'll leave it at that.
Thank you. And I don't see anybody else. That's Councillor Miller. Somebody else there?
No, thank you, Mr. Mayor. I don't think we solicited the people online, or I'm not sure fully if everybody has had a chance
Okay.
out there. I know they
No,
are
that's-
checking.
No, you've already, other people can talk. No, you've already talked, sir, as well as Mrs. White.
When are we doing
No.
objections?
What's coming up?
Okay, that, I have an objection for later. I just want to make sure I don't miss that.
Or just clarification.
on what was, those two statements at the end there caused confusion, so would there be some kind of statement from the RM to clarify what was just said between Mrs. Nyland and the provincial representative here? So
Yes.
that it's clear what
Yes.
the process is, so that the public can know.
Okay. Yes.
Very clear. No?
Well, I think what the provincial representative is what we'll be following.
Anything, Tanya,
So-
from outside?
So as long as
Okay.
these changes are discussed during this public hearing, council can make those changes without having to close this and have a second public hearing specific to those. We can discuss it all as part of this initial public hearing.
We don't know what they are yet.
We know what they are from the provincial report.
We don't know what they are.
Yeah, we don't know.
It's all posted on the public agenda, so that's open to everybody to read.
All the documents are there. So if that's been answered, and I think it has, then we can move on. We've asked the foyer. There's no people there for inquiries. I'll move it on to those in favor.
This will be short. This will be
Well,
easy
just
because.
hang on, Vince. Howie had his hand up for first, and you'll be next, Vince.
You guys going one?
Yeah.
There were lots here, Vince, but they got fed up and went home. Howard Berdeen, a longtime resident. Family's been farming in the area since 1890s and business owner. And I just want to speak in favor of bylaw 2609, although in some publications that I saw during this week, it's called the Patharian bylaw. So there's some misinformation about that. I don't believe it is. That's more credit than I will give you, Mr.
Thank
Mayor.
you.
And so let's use the proper term. So this is zoning bylaw 2609, which I had the privilege of being on some committees. I actually say this process goes back 12 years. And I think, Dan, I wouldn't be totally wrong by using those numbers. And there was a number of consulting groups. I was on businesses, I was on farms, and I was on church groups that were asked stakeholders to come in and speak on these issues. So there was lots of that. I had the privilege till I was fired to be on council the last 4 years before this term began. And we had hours and hours of discussion as councillors. We had hours and hours of public hearings. I look around this room, I see a few of you that I recognize, but you weren't out those years ago fighting for this at that time. So I would say you came in a little bit late, but it's never too late to make changes that do make sense. So anyway, this process has gone on a long time. There are young families in this community getting frustrated with this municipality. I'm actually relieved to hear that only 900 people signed the petition when there's over 16,000 people in this municipality. So the majority is out there. There is a rumbling. I know there's a group working very hard in one direction. There's a rumbling going on, and I think people will be surprised the next election. But I speak in favor of this. I believe it is basically the same bylaw that 25, I just forgot the number. Lots of study has gone on to it. Yes, there can be some productive changes, but this thing must move forward to see this community move forward. My question is, if one of your family members wanted to stay here in this municipality and build a house, that would increase the housing and the population greatly. You've got to be ready for that because it's not fair that our own people cannot stay here. We need housing that is low cost, and that means smaller lots because people can't pay for the big lot. There's lots of reasons for that. So a standard lot does not work. I believe we could have tiny homes. I believe we could have a trailer park. There are many ways that we could help bring our young people back in here too. So it's time to move on. This was supposed to be passed a long time ago. We've been past the time limit. Dragging our feet, it's not going to work. So I just want to encourage you. There's 16 to 17,000 people. Only 900 are saying they're opposed. And I actually ran into 5 people that said today they got rid of the people bringing the survey because they just wanted them. They signed it, but they didn't mean it. So there's 5 less. I think that means 895. Thank you.
Thank you.
Why am I not on?
Oh, who's that?
Hello, my name is Lena Penner. I am on Zoom. So have you given us a chance to speak, the ones that are
No.
attending by Zoom?
I did ask, but I'll
Okay.
hang on there, ma'am. I had a question from Councillor Miller. Go ahead, Councillor Miller.
Thank you, Mr. Mayor. Are we allowed to ask the presenters in questions?
Well, who is it that you want to ask a
Well,
question
Mr.
to?
Bradeen.
I don't know if he wanted to answer any questions, but that's up to him. It's he's free to answer any questions.
Okay, so Mr. Bradeen, you are absolutely in favor of this. You were obviously on the last council that got kind of purged, but it didn't go through. The people felt differently than your opinion. I know the people in my ward want rural residential. They do not want high urbanization. So I take a little bit of caution and offense to what you're talking about, these tiny homes in Cooks Creek or Hazel Ridge or Pine Ridge or anywhere in between. We live on acreages, as you know, 5 acres and great, you know that. But
I'm
my
not
question
talking
is,
about your area. I'm talking about the area that I represented. So urban areas are asking for smaller lots. It's a known fact, and so you can't deny that.
So you stand for urban, you stand for urbanization. I don't. The reality being, can you give us about 5 points why you are so in favor of this? Why you are so in favor for changing the actual composition of our community?
If you look around southern Manitoba, let's look at Niverville, a town that's right, but we are. The same type of people move out to Niverville that move out to this area. Yeah, well, we'll just disagree. I can't
just let him speak, Councillor Miller.
So I'm looking at what's going on, what the developers are, the builders are saying to me, we're losing our builders that want to build any houses. And no, it's because we can't build houses in Oakbank right now till there's a water treatment plant. And that's another problem. We can't build seniors housing, where most of these people are going to have to be there in 5 years. And so that's the that's the reality.
Let him speak, people. Be
I'm
respectful.
not running for election, so I can talk honestly.
Be respectful.
Okay. So anyway, that's where I'm at. It's just, and like I say, there will be a backlash on this too at some point. Maybe not this election, but if we stay too far behind, it will change. There will be negativity. So that's just my take on the situation. And so I have the right to give that opinion as much as those that are leading this group of tax rate payers. They've got their own ideas too of what it should be like, but it's not everybody's opinion. And like I say, 900 out of 16,000 is not a majority.
Mr. Bradeen,
Not a debate.
Okay, let Mr. Bradeen be.
You had a lot of acreage in this community. You garnered a lot of money through development.
No, I didn't. It was my father's land.
Why isn't my video?
Do you have nothing at stake here personally to benefit you?
My dad is going to die someday, and then I will get an inheritance. Yes.
Boom. Thank you.
I'm at a loss.
I want to ask Mr. Bradeen question.
No, he's not here to be
Yes,
interrogated.
you said we can ask questions.
Well,
Now
he's
we
already
can.
asked the question. He answered the question. I'm not screening anything.
Every council can answer the questions.
It's up to you, Mr. Bradeen. Otherwise,
Oh, yeah, feel sorry for Mr. Bradeen.
I don't
yeah.
feel sorry for anybody. I'm trying to make it fair.
Well, ask Mr. Bradeen if you want to ask question or not. If you like to answer the question, like, come on. You're treating people with different
Okay, I think he's already answered the
respect.
question.
Yeah.
It's up to him whether he wants to come forward. Mr. Vince, there, if you want to come up. You know, enough of the mumbling, okay, guys? Just let Mr. Radeye.
Tell me when you're done.
Yeah, go ahead.
Are you done? I'm ready. Okay. So I'm going to speak in support of updating a zoning bylaw.
Who are you?
Oh, sorry. My name is Vince Rattay.
Thank you.
So I know I'm going to go back quite a few years. Howard went way back to a time where he was on a board. I was actually on some of those stakeholder groups. So that big, thick WSP document, I was on 2 different stakeholder groups. I met with the Minister of Municipal Affairs 2 times. And Dan Doucet will recall what some of the issues were, but at that time, the zoning bylaw had some real serious issues, which is now still the current zoning bylaw, was now 16 years old. So we've been working on the zoning bylaw. It was part of the development plan, you know, stakeholder groups way back under Bob and Nark. And then that morphed into zoning bylaw. So I have a zoning bylaw book that Dan Doucet gave me that I've read cover to cover as much as my Bible, maybe more actually, for a couple of years while we were moving our farm. So I understand a lot about zoning. I heard a lot of really good points here. And so I actually have a question is, where in the last 4 years since the municipal meeting said, municipal guy said, go back and redo everything, were there not stakeholder groups or consultancies or anybody, like all these great things I heard, were letters not sent? They talk about small, like the vet lady, residential farms and all that. Was that not brought forward and presented at any point in time over the last 4 years? Was any of that, I have a question, was any of that included in the zoning bylaws? Okay, so I got a couple things, because I'm in favor of updating the zoning bylaw. Maybe, I don't know if any of you people are actually in favor of it, but I'm in favor of it. But I do see that there's some things that perhaps could be reviewed. Things like, you know, people who have houses on VRBO and doing Airbnb. I think those houses should be taxed differently, is my opinion. I think there's some tax dollars that should come into the RM. You don't want to live in that house. You want to treat it like a business. Pay more taxes. That's my opinion. Anyways, you can do with that what you want. There's some really good things that I heard. I think there's some people don't maybe understand the process in this room of what happens. You do your first reading, then you debate it all, you go through it, you hammer out the details, and you come back. And I think you come back with another thing. So I would volunteer to be part of a stakeholder group. I know my wife will hate me saying this, but particularly when it comes to like agriculture, I know Howard was on the ag group, so he was on agriculture. I was on another group. I was on a ministerial group, because if some of you don't know this, but you know, if the church out in the country burnt to the ground, you couldn't just rebuild the church if it was more than a 50% loss. So why couldn't we have Dan knows this? This is why we met with the Minister of Municipal Affairs. You know, having small churches out in the community, out in West Pine Ridge. What do you mean we can't put a church out here? Right? So we did all of that. So we did a lot of work. So I'm going to continue on with a couple of different things. A lot of good things were said. I don't think anything was major. I think a lot of those things are tune-ups and adjustments. Some of it is to verbiage, some of it is to wording. I think some of that is all good. I don't think anything that is a threat, but I think that you can't lose sight of the forest for the trees and whatever. The current development plan is I guess what it's 2010. Current existing
zoning bylaws 2010.
2010. So you do the math, it's 16 years old. The development agreement, or development plan, sorry, is now what, 8 years old? Ish. So there's things that are currently out of sync, and I think significantly out of sync. So we do need to update the zoning bylaw. It has to happen, and it should happen soon. And unlike Andy, well, we shouldn't rush it. It's been 8 years. Ha ha. Sorry, Mr. Kaczynski. It's time to do our job. We have to actually take this seriously. Time to do our job and go at this thing and do it. And it's not Pat Terrian's thing. This goes back to Bob and Nark. All the consultations, all the things. I was there inputting in all the time, and I sacrificed a lot of time to be there. So you know, at some point in time, we have to do things what the province asks us to do, and we have to update. So we think about updating provincial legislation, regulations that are changing since the current bylaw was adopted 16 years ago, including environmental impact, land use, conservation, density, and so on. And densification was a concept we talked about because we want to preserve ag land. You can't say we want bigger lots and then say we want to preserve ag land in a rural community. It doesn't make sense, not logically. So if you have to urbanize and make smaller lots, inside a town so that you can preserve ag land outside the town. That's how it works. So new land uses and development trends that need to be recognized. Things like Airbnb and VRBO. We need to understand that. So existing gaps and inconsistencies should be corrected, including places for churches and places of worship. So that was in the new zoning bylaw. As far as I know, it's still there and hasn't been removed. Also clear regulations for supporting, now this is a personal thing. I wrote a white paper and I sent it to the municipal affairs on agritourism because there was nothing in the current bylaw for agritourism. And also the small orchards, how many acres and so on, 5 acres, you can grow berries on 5 to 10 acres, but strawberries on more than 10 acres is a tough challenge, right? So anyways, all of that stuff needs to be passed so people can get things done. People can do things. They can farm.
When
they
do
can move
Zoom
out here.
people
They can
get to
start their
talk?
backyard dream
When
and
do
do whatever it is they're going to do that makes sense in the zone that they are in. So the zoning bylaw should be updated to include new and permitted conditional uses that reflect the recommendations of the previous stakeholder groups. And I believe that most of that is in there. An updated bylaw creates opportunities excuse me, for economic growth and increased tax revenues. In West Pine Ridge, where I live,
When do
it's currently
Zoom people
zoned
get to
A20.
talk?
And
When do
I
Zoom-
asked for some information on this because the development plan says West Pine Ridge is supposed to be 5 acres. And so I had a question about taxes. And there's a lot of people who have $1 million homes and just a bunch of grass and whatever in the back. They don't use their agriculture restricted land for any kind of agriculture at all. Zero. Nothing happens. I'm the only guy with cows in my backyard. There's a few sheep and goats down Deacon Road, if you know where I live. But they're not using it for agriculture. So should they be given a tax advantage when they have their, $1.5 million house on 20 acres of nothing, doing nothing with it? Or should they be taxed as residential? So this is, because that's really what it is, right? And I know that if you have how it splits off, I get 5 acres from my house, it's taxed at full rate, and the back, however many with my cows, that gets taxed as agriculture. And I don't know how it works for all the other people if they're taxed at full rate, but that to me is lost revenue. If that's really, if they should be paying their fair share, I'm just sitting on this and I'm some rich guy, got a lot of money, and I'm just sitting on all this land, doing nothing with it. Shouldn't you be taxed accordingly? You're not an agricultural person. You're not anything. So anyways, that was a thought. But anyways, going back to that area, I understand what's supposed to happen with the development plan. And the zoning bylaw would go through that and say, okay, it's all standard now. Everybody's kind of on the same footing. And that would affect me as well. I'd, now be taxed accordingly. I'd have to pay a little higher taxes, but I understand how that works. All right. So anyways, I think the time of 8 years, 10 years, however many years, it's time to make the shift, make the change, and make it a priority. And I don't feel like it's been a priority. I asked Mr. Miller, we met in I think it was January after you were elected, we talked about the objections. I asked 3 times what the objections were, and I never did get an answer. I didn't. What were the objections? Because are they frivolous? Are they real? there's some good stuff in here. And I would have appreciated a response on that because I would have had input. Because I'm an independent thinker, right? I'm not here for anybody else except me for tonight. So anyways, it's time. This cost to the RM, delaying the zoning bylaw comes at a cost. We spent $750,000 to $1 million to the previous WSP under Bob Bednark during his time as Reeve. Those costs don't reflect any new added costs and all the consultations on all the secondary plans, as far as I know. I believe the secondary plans are on top of all of that for Oak Bank, for West Pine, and whatever other public meetings and consultations. I did request actually and right to get those numbers, but I don't have them here. So plus all the staff costs. Like we're spending money on this. I'm spending money on this. I'm a taxpayer too. So I'm spending money on, so are you, on all of these other things. So the cost to the RM grows as we delay things. Now, I know that you don't want to ever make a bad deal. And how many know in a good negotiation, nobody walks away really happy? In a good negotiation, nobody ever gets what they exactly want, but it's a good deal. It's a decent deal. That's kind of how negotiations work. I think about the continued staff time spent working on these outdated regulations and trying to move us forward. The longer the update is postponed, the greater the financial impact on the RM. Things like delaying projects, construction costs, consulting fees increase when projects are delayed or restarted. So there's never a savings to be had by delaying or postponing a project. You don't save money by delaying it because inflation keeps driving things up. So lost municipal tax revenue from projects that are delayed or discouraged. So the purpose of a zoning bylaw should be to support the development plan. So the development plan is passed, it makes sense, the zoning bylaw follows. And the development plan establishes a municipality's long-term vision, so we have that. And zoning bylaw is the legal tool that puts vision into practice. And having read the zoning bylaw, I'm going to say something about some of the things that I've heard, happening in the community, saying the zoning bylaw update will cost 80 million. People have said that. I've got pictures, I got things that were done in writing, and there's no link to substantiate that. That's not substantiated. And if that was what was used to get people to sign a petition, then that's shameful because it's just not truthful. You can borrow money at any point in time, pass all kinds of things for capital projects without updating the zoning bylaw. I mean, that's true. You can have a borrowing bylaw tomorrow and pass it if you wanted to. So anyways, I understand the whole thing with the water and all that stuff. And I live in the country and, we need water in town. I get that. Everybody's kids go to school. Sorry, I don't want to ramble. Go back to the thing here. The long-term vision, we need the zoning bylaw to allow the teeth to be put into place so that when people develop, it's done properly. And again, there's a whole bunch of good suggestions here that, I thought were very helpful. And I don't think any of them were major. I think there's some of them were, again, just tweaks and some adding a little bit thing, a little more definition, a little more detail. That doesn't hurt us. It is more time. It's a pain in the butt, but I think that's worth doing, and I think that there's a lot of people could say yes to that. At least I hope that's why they were pointing those things out. I hope it's not just a mere stall tactic, but I hope that in their hearts, they're actually concerned about our RM and want to see something done so we can actually move forward, but in the right way. Does that make sense? Because if you just want to stall it, then your heart's in the wrong place. If you want to move forward, then you got to do the work. You okay? Am I okay for time?
Don't look at me.
All right. Updated zoning provides clarity, consistency. You guys mind? Do you mind, guys?
Mr. Kuffner.
I don't like competition. I never did.
Mr. Kuffner, we'll give you an extra 20 seconds there.
Updated zoning provides more clarity, consistency, and fairness for residents across the board, businesses, developers, council. Everybody knows exactly where everything stands at any point at that point in time, and it allows us to take the step to move forward. And if people are in the right, they can go the right way. If they're in the wrong, you can tell them they're in the wrong. We've got the zoning, we got everything lined up and matched up. So it is time to do something about it. So we take it seriously. I'm not, of the mind that we're rushing it through. It's been 12 years. That's not a rush. It's not a joke either. There are people who are waiting for things to happen. We've got seniors complexes going up. We got swimming pools going up here. We've got different things. And there's are good things in our community, and the zoning and the bylaw and everything has to work together. Anyways, I'm done. Have a good evening. Thanks for coming out.
Thank you very much. There's people online here. One lady, I'm sorry, I apologize. You're probably waiting a long time. That's Mrs. Penner.
Yeah, I'm Lena Penner. I'm from Cooks Creek.
I apologize. Firstly, ma'am, I apologize. It took us so long to get on here. I didn't see you on there.
Yeah. Yeah, and I guess the 15 minutes that everybody has, I guess it's just really important that, that the time is kept for everybody the same way, right? So
right.
Some people were cut off quite soon after their 15 minutes, and some people, have been able to go on for quite a while. But my question is, and I'm a little bit confused about the process, so I just would like some clarification. My understanding is that the province just gave some recommendations that people just received today, I think. And so if we as citizens want to review the recommendations and then discuss them at at another public hearing, what is going to be the option for that?
Moving forward, we have the document online. It's hard to do since you're online there, but it's 37 basically addendums that the province wanted from different departments there. About 8 or 9 pages, 37 addendums there. Some are required and some are recommended there. And they're leaving it up to council to do that. We were only advised of this document on the 23rd or 24th. I think it was dated the 23rd. We had a revised document there that they sent back to us, the province, and we just received that today. So the revised document there is, I've gone through this one quite thoroughly there, but the new one there, my understanding, it's just the addendum part. They gave us the whole package again. So that's the one change that's on there. As for, I'm not sure if I got this right. I'm going to assume this is the right question, is that when we're going to do a public hearing, or if we're going to do a public hearing following this. I don't see that we're going to have time to get through it all there, but I think we are going at a pretty good pace in any case there. And it's already 9. So I don't know the last part, if that's your answer or your question there, ma'am, for the second part.
Well, I guess I'm asking is, after the document is reviewed, is there going to be is there going to be an opportunity for another public hearing, or to continue this hearing after everybody has had a chance to review the last recommendations from the province?
That part we're going to have to discuss as a council. Probably at the end of the night tonight, we'll have a better idea of how we're going with regard to this public hearing.
So sorry, so then do we have to, so we have to stay on, and then you guys are going to present your decision, or I'm a bit confused about the process.
The process tonight, you don't have to stay on. We'll advise, or you can get onto our website, and we'll be updating our website with regards to that.
Okay, and so if you say there's no further public hearings, then it's just going to be, there's not going to be any opportunity to have a hearing about these new recommendations?
Well, with the new recommendations there, if there's any there, that's what we don't know. It's kind of it's a living document. I think I used that term
right
further there. So it's a great answer there. Will there be another public hearing? This one continued there. That part we have to stay tuned, I guess I'm telling you.
Okay. All right, because I would like to have the opportunity to look at the recommendations and then to
Definitely.
So that would be sort of my request, is that we would have an opportunity to look at them, and then continue with the public hearing. And then the second thing is just so you know that I came to the meeting and I was in the foyer. And it was not a very comfortable place to attend a public meeting. There were no chairs, and I stood for quite a while. It was difficult to see the television. It was difficult to see the speakers. And so I'm just requesting that the next time there's a public hearing with a lot of interest from the community, which I think is a wonderful thing, that the community is so engaged, that we could just make it a little bit more comfortable and really reasonable for the public. There are quite a few older people out there, and I think this would be this is not really encouraging democracy, that there's not really space for people to sit comfortably and ask the questions they want to ask.
Very good points, ma'am.
Yeah. Okay. Thank you.
Thank you, ma'am. Was there somebody else online? If somebody can let me know if a hand goes up there. It's 9 o'clock. I'm wondering if we could have a couple minutes there for. I don't think everybody's quick for that there. If we can have a break there just for 2 minutes for nature to do its duty there, back at 9:10, please.
Recording stopped. Recording in progress.
Thank you very much, ladies and gentlemen. Ladies and gentlemen, if we can get back at it there. If anybody has their hats on, please take them off in the chambers, please. Thank you very much. We're back to the meeting at 9:17 p.m. A little later than 2 minutes, but that's good in any case. There, we're just finishing up for those in favor. There's Mrs. Penner. We spoke with her. Anybody in the audience or? No, I was just saying I'm finishing up for those in favor. I'm not saying what Mrs. Penner was saying there. I don't see anything more. Is there anybody out in the audience? I know they can hear me for in favor. Online or on the monitor. I see nothing. Then we can go into those in opposition.
There's open seats. They don't, anyone else say.
Then we'll go with Daniel, Edwin, and then Elizabeth.
Edwin?
Can I just ask one thing?
Yeah.
If we already know that some people have short presentations, could they maybe do that and then if that's okay with everybody and then we go, or if like Tanvi is saying she possibly can't be if there's another hearing, can that be done?
Okay, well then we're going to go with Daniel and Edwin then for now, and then if Tanji's short on time.
Hey, good evening, Council. My name is Dr. Daniel Page. I'm your local computer science professor on Pine Ridge Road. Tonight, I'm registering my opposition to zoning bylaw 2609 on multiple grounds. My issues compound from the preceding zoning bylaw that was proposed, 2125, but I believe the three main issues I have stem from the process right from its starting point for 2609. Need for better transparency and accountability mechanisms and elements of 2609 and improvements of the bylaw itself. It is being stated that zoning bylaw 2609 being introduced is starting over. That's a quote. The process, thus, is a new process. So I believe the RM must treat it that way in a procedurally fair manner as per the Municipal Act and the Planning Act. If our municipality is to move forward with a new zoning bylaw, it must respect the process, ensure the public is a part of that process, and that the zoning bylaw reflects the will of the RM of Springfield and how it wishes to zone and make decisions of such and do so correctly. Now, I have additional comments, but as was communicated to council and to planning, a resident could not be in attendance today, and I'm willing to take time away from my comments tonight to read her comments. She's one of my neighbors, Cynthia Sinclair.
Mr. Page, we've got her copy of her statement there. It's online.
Okay.
Your choice. If you want to still read it there, but everybody has it's online there, and so you could either forego that or go ahead. But I'm not stopping you.
I would like to. I'm just going to read it because it's related to my comments.
Okay.
But remember, this is just her comments. I'm just trying to represent her because I want to make sure everybody's perspectives are represented.
Okay.
Mr. Mayor and esteemed councillors, before I speak on specific issues I have with the proposed bylaw 2609, I would like to comment on how the RM communicates with its constituents. I do not make the habit of checking the RM's website for updates, and in fact, usually only access the website if I'm looking for specific documents or information. I also do not pick up the clipper. So the only reason why I know about tonight's public consultation on the proposed changes to the zoning bylaws is because my neighbors had mentioned it. The fact that the RM of Springfield has a presence on social media, i.e. a Facebook page, should make it easier to reach more Springfield residents. Instead, I was surprised to find that the notice for this public hearing was not posted on Facebook. And I look back to May 1st of this year. Yet other activities, such as the temporary disruption of 911, the community safety and policing survey result, municipal office closures, roadworks, etc., were. This leads me to believe that the Arm of Springfield is not really interested in public feedback except for certain things, and was as mandated by the municipal board. The zoning bylaw affects all residents of Springfield, and considering the previous iteration of the bylaw, 2125, was met with such opposition, resulting in the municipal board's June 5th order, I would have thought that the invitation to a public hearing would be widespread and well communicated. Well, Section 74(1) of the Planning Act states that public consultation can occur before or after first reading. I would think, given all the objection last time, that this council would have used that opportunity to have meaningful public consultation prior to a first reading, then make appropriate changes to the document. When you consider that very little has changed from 2125 to 2609, and 2609 has passed first reading, it begs the question, what do you do about the feedback you received the first time around? And will you do anything with the feedback you received tonight? I, among others, gave presentations which outlined concerns on certain sections of the proposed bylaw back then. As I read through the section I presented and compare it to the new 2609, I see a couple of minor word changes, but the intent remains the same. So I guess my feedback was invaluable or ignored. Will that happen again? And why, after public consultation, does the RM not collate and post or make public in any way those concerns, objections, and suggestions for change before proceeding to a second and final reading? So again, I will only speak to the two issues brought forward. Just for context, we're talking about the letter that I'm reading right now. Issues brought forward last time. I object to the wording in section 2.2, which changes development officer to designated officer. While I am sure council will say this wording change makes it consistent with the Provincial Planning Act, it makes little sense to make this change and could potentially create more confusion, resulting in inappropriate land use decisions. The Provincial Planning Act uses terminology to cover all the possible municipal government structures within the province, i.e., not every municipality has the position of development officer. There are a number of designated officers in Springfield, including the CAO, fire chief, police chief, etc., none of which should, it's bolded here, should have the responsibility of making interpretations and decisions about permits and land use issues. In addition, that the bylaw does not state how such a designate will be appointed. Will there be multiple designates appointed for different situations? Will there be a designate of the month? These designates could potentially make zoning and land use decisions without proper knowledge of the issues or without public consultation, where required such as for permitted or conditional land uses or other planning options such as variances. If the intent is to maintain the position of the development officer, then let's continue to use that wording in the bylaw. Secondly, 2609 gives such designate the power to make zoning and land use decisions for minor variances without public consultation or other due process. While the term minor variance is discussed in section 102 of Planning Act, it lacks definition and only describes what they are limited to. There are a couple of examples of common variances, which I believe she is referencing the planning, the Planning Act's handbook, one on minor variances, section 6.3. There are a couple examples of common minor variances, but again, this is not really a definition. The Planning Act allows the applicant of minor variance to appeal a decision. The appeal process is then the same for a full variance, including a public hearing. The proposed bylaw 2609 does not provide a definition describing what is meant by a minor variance and fails to even provide, at a minimum, an example of a minor variance. There is no mention of a process for appeal, including requirement for a public hearing. The taxpayers and voters of Springfield deserve to know what a minor variance means, for as it stands, it appears to be a blatant attempt at gaining the power to make unilateral decisions that could potentially affect us all. I continue to object to the wording in section 2.53, formerly 2.54 in 2125. Essentially, nothing has changed from the last iteration of this document. My original objection stands. Development agreements resulting from rezonings or subdivisions, etc., should be further required in the bylaw to address and include appropriate concerns raised during public hearings, and that may be included as part of the development agreements that then must be registered as a caveat on the property. In addition, enforcement on all conditions should be clearly spelled out. Tightening up this wording would ensure not only that proper public consultation occurs, but also that the public's will is acted upon, thus preserving the very basis of our democratic rights as citizens. And this last statement is perhaps the most important. It is my opinion that if this bylaw is passed in its present form, with so many shells changed to mays, the loopholes that allow unqualified people to make decisions about land use or even interpret provincial planning laws, and the potential for unilateral decisions by council or its inner circle is a direct assault on Canadian democracy. This council was elected to serve the people of Springfield. It is a sacred trust. Decisions made by this council should be carefully considered and reflect the majority opinion and needs of our residents. Thank you, Mr. Mayor and Councillor members, for your attention and consideration. Mrs. Cynthia Sinclair, 63054 Pine Ridge Road. So that concludes that statement. I wanted to read for her. Those are her views. So previous to the publication of the Manitoba Municipal and Northern Relations Planning Report, or I'll call it Provincial Report, being made available to the public on Friday, July 24, 2026. I had more substantial comments, but I believe some of them have been addressed in the province comments. Keep in mind that currently we're playing around with first reading right now, so those changes are going to be needed by default, some of them. So hence, due to the changes of information in such a short period of time, I've decided to revise my comments and submit them in a way that will be respectful of your time in consideration of those comments. To ensure I have sufficient time, I'm going to limit my feedback to more narrow matters. So I want to say something positive. I want to commend the efforts to help streamline planning processes, including if it is along a pathway of provincial standards. However, it is my view that good governance be effectively balanced with mechanisms for accountability to ensure government decisions are effective. So I'm going to raise a couple of concerns around transparency. So first, according to the RM of Springfield, the process has been started over with 2609. Page 10 of the provincial report in tonight's agenda states that 2609 is substantially similar to bylaw 2125. This bylaw faced significant opposition for numerous reasons, some of which are communicated by the Manitoba Municipal Board. Planning Act 74, subsection 1, offers council the opportunity to get community feedback to actively shape the draft, because we're talking about a draft tonight, even though we passed first reading, by even permitting a public hearing to occur before first reading. Council has chosen not to do this, meaning the entire public is once again discussing issues that derive from the previously proposed zoning bylaw 2125 tonight once more. On June 16th, so this is the second, June 16, 2026, the RM Council meeting that immediately preceded June 25th, 2026, planning meeting where Council considered and voted on the first reading of zoning bylaw 2609. It was stated openly by CEO Draper that a discussion happened between Council and the administration on how to proceed. At approximately 6:31 p.m. of that meeting, CEO Draper stated, "We are working on that timeline now," referring to the bylaw and the process. I have not located this timeline, and it appears it has not been publicly published. I believe if the administration has a timeline, that Council should ensure it is published so all parties can understand what process the government is gauging in for those that are interested, regardless of their position, to know how this process may proceed. For example, based on what has been published at this time, we do not know if there is any planned further consultation other than tonight, any consultation or open information sessions and the sort, nor when ultimately Council anticipates considering second reading so they can ensure they have thoroughly studied the bylaw first. Just as a side note, I've heard some concerning remarks here among council that some have said that they didn't read line by line this bylaw. You need to look at the Municipal Act. Be very careful. There's a specific part about making sure you have opportunity to review the bylaw. Now, I'm going to move now to two specific comments. The first one is, and this is something I raised during 21-25's public hearings, but again, I'm hoping that we treat this as a new process, so I'm bringing this in. I have concerns about the arbitrary nature of rural residential versus agriculture-related zoning classes. This isn't not necessarily as a result of the proposed bylaw, but as a broader contention. Some areas of this RM have very arbitrary use cases for these zones that are hard to understand where they arose or exist in the proposed bylaw. There are plenty of examples where RR-like zoning also exists in AG-like zoning, and vice versa. For example, in Sunnyside, this is pretty common. Clarity on how these decisions were made, like that table, would be especially helpful for the public as going ahead with this matter. That would be very helpful. Second, this is a technical matter. Tables 9.1 and 9.2 seem to be especially important tables in this bylaw. Many will review these tables probably when making decisions. Section 9.3.1 is conceptually confusing. Within 9.3.1, it simultaneously defines table 9-1 and 9-2 as prescriptive assignments of land uses and activities to general use categories. In other words, an assignment that is unambiguous for use X to assign category Y, then shortly thereafter describes it as a category system, defining a method, and then discusses a classification. These are all different objects, mathematically and logically speaking. They're proscriptive, prescriptive, and there's this issue of ambiguity when you start talking about an assignment. An assignment cannot have ambiguity, which the final sentence allows in this subsection, the one that's referring to a classification. So it never states who resolves such ambiguity, which will be important to include in this section. The decision whether it should be decided to be prescriptive in how they interpret the tables, i.e. classification, or proscriptive, i.e. an assignment, and consistency of language matters. You cannot have a rigid assignment while introducing ambiguity without defining the arbiter, and I think this was raised earlier, is the arbiter of these decisions. In this particular case, we're just talking about the table. I will note that previous language in 21-25 in this subsection was clearer, in my view. And the last thing I do want to note in my opposition, I do have it in my written comments that I submitted this afternoon. I did give some suggestions on how to improve accountability for the designated officer's decisions, such as defining what a minor variance is more explicitly, the conditions around that, because there is a percentage associated with it in the Planning Act. In addition, introducing mechanisms so that it's more transparent what the designated officer is exactly considering for the decisions, such as including a public registry. That's something maybe to consider. And of course, creating better mechanisms for appeals so that matters can be raised from, say, for example, a minor variance to a full variance. But to be respectful of time, I will encourage council, the staff, to listen carefully to the concerns of the residents here tonight at this hearing. Thank you very much for the opportunity to provide comments. Have a beautiful day. Thank you. Sure.
You said mathematically you can solve this problem?
So I study scheduling theory, and I spent a lot of time studying assignment problems. So like many years I've been studying them. So an assignment, so you got to imagine assignment. So
Just a real short answer.
Sure. Short answer. Say you have a bunch of jobs that you want somebody to complete. You assign the jobs to the people that are going to complete them, right? It has to be unambiguous who gets the task. So when you look at the table that you have, when you read it, it's the question of prescriptive, which a classification system would give you, is, hey, look, these are bins, and there's going to be somebody that's going to help figure out which bin it belongs best in, or we're going to be going this assignment route where there's already a process, which they describe as a method. And this method isn't quite clear from what is written literally here because you have possibilities of overlaps of the categories. So it's just seeking clarity on what to do with those overlaps.
Okay. I think I got that.
Yeah.
Thank you, sir.
No, anytime. No, thank you very much.
Need a chair, I'll grab one. Check. Name is Edwin Giesbrecht, longstanding resident of the municipality of Springfield. Today we have a submission to the special meeting of council. This is on the proposed zoning bylaw number 2609. Mr. Chair and members of council, thank you for convening this special meeting to consider proposed zoning bylaw number 2609. Before discussing a single provision of this proposed bylaw, I respectfully ask council to consider a few simple questions. Let's say it this way. Does council believe the residents of Springfield are fully capable of understanding a zoning bylaw? Does council believe the ratepayers of Springfield are fully capable of reviewing structured revisions, comparing one document with another, and forming their own informed conclusions? Does council believe the electors of Springfield deserve a genuinely fresh, transparent, and meaningful legislative process before being asked to accept one of the most important bylaws this municipality will ever adopt? If the answer to those questions is yes, then I respectfully ask one final question. Why were the residents, the ratepayers, and the electors of Springfield not given what a new bylaw number would naturally lead them to expect? A genuine new beginning. After two Manitoba Municipal Board rulings and the referral of proposed zoning bylaw 2125 was not valid, many residents would naturally expect that new bylaw number would also be accompanied by a process that was unmistakably new. Yet administration's own report describes proposed bylaw number 2609 as substantially similar to proposed bylaw number 2125. That leads me to another question. If council believe residents were fully capable of understanding those revisions, why were they not simply shown those revisions openly, honestly, and transparently from the very beginning? I have carefully reviewed the many objections submitted by Springfield residents, including the common petition signed by hundreds of eligible voters. The petition states, "We, the undersigned eligible voters of Springfield, object to this proposed zoning bylaw because it will reduce public involvement in land use decision-making and facilitate increased development that will cause premature expansion of infrastructure." I respect those concerns. They focus primarily on what many residents believe this bylaw may mean for future land use decision. My objection begins much earlier. Before we debate how this bylaw may affect future development or future public participation, I respectfully suggest that council should first ask whether the legislative process that brought us here today earned the confidence of the public. My objection is not founded upon opposition growth. It is not founded upon opposition to updating Springfield's zoning bylaw. Every municipality requires an update zoning bylaw. My objection is whether, after the history of proposed bylaw number 2125 and 2 Manitoba Municipal Board rulings that its referral was not valid, the residents of Springfield were provided with genuinely fresh, transparent, and procedural fair beginning they would reasonably expect from a new legislative process. Mr. Chair, members of council, I also want to make my reason for objecting abundantly clear. As a resident, a ratepayer, and an elector of the rural municipality of Springfield, I have lost confidence in this legislative process. After 2 Manitoba Municipal Board rulings that the referral of proposed bylaw number 2125 was not valid, I reasonably expected that a new bylaw number would be accompanied by a genuinely new, open, and transparent process. Instead, administration's own report describes proposed bylaw 2609 as being substantially similar to its predecessor. Whether intended or not, that process has left me questioning whether the new bylaw represented a genuinely fresh beginning or merely the appearance of one. As a resident, I believe the people of this municipality deserve better from all their governance. They deserve a legislative process that earns their confidence through openness, transparency, and procedural fairness. The first question before council is therefore not whether Springfield needs a new zoning bylaw. The first question is whether the process that produced this proposed bylaw has earned the confidence of the residents, the ratepayers, and the electors of Springfield. Because every decision of this council ultimately depends on one thing: public confidence. If public confidence in the legislative process is lost, confidence in the outcome and confidence in each and every member of this council become increasingly difficult to restore. In the end, it is the electors of Springfield who determine whether that confidence has been earned. Respectfully, I submit this is the first question council should answer before considering anything else. I thank you. And I would like to make just one last note, Mr. Chair. You indicated earlier pandemic and seating facilities, and I distinctly recall in the last administration during the pandemic that in fact we moved one meeting over to the fire hall right next door. I suspect you could have as many as 500 people in that square footage if need be. Just move the fire trucks out for an evening. You take care now. Thank you.
Opposition.
Yes. Yeah. I would say.
Yeah, or Andy?
Yes.
Okay.
I take it for my turn.
So thank you. Whoa. So thank you for allowing me to speak, jumping the queue today. Also to Dr. Herečka, Hersa and Georgina Mustard for their help in that too. So my name is Tangi Bell. I'm a resident of the RM of Springfield. I have numerous issues with the proposed bylaw 2609. Due to the time constraint for presentations, I will restrict my comments to the following. And request to work with council in the future to address my other issues. Now, these comments are not based on the revised info provided today, so I am concerned with the RM's level of public engagement, considering the importance and long-term implications that a zoning bylaw has on a community. We're at the height of summer vacation season and municipal elections are in 3 months. This time constraint will, without doubt, once again result in a lack of meaningful public engagement and an expensive municipal board hearing for Springfield taxpayers. I request that council defer this important issue and allow the next elected council to properly engage with and implement citizen input on this important issue. I'm also concerned about the use of may and in the opinion of council. These appear 105 times in the 81-page document that I read. It is inappropriate for a bylaw, which should be definitive and clear, not subjective. So I request that subjectivity be removed and replaced with certainty and consistency. My next point is the proposed zoning bylaw once again does not conform with the development plan vision to, and I quote, protect the natural environment, including clean groundwater. Section 723(1) groundwater protection of the proposed zoning bylaw states development in areas sensitive to groundwater contamination shall require a site-specific hydrogeological assessment completed by a professional engineer licensed to practice in Manitoba. A professional engineer typically focuses on the design of infrastructure and not on aquifer characteristics and groundwater quality. So I request that the proposed bylaw strike out professional engineer licensed to practice in Manitoba and replace it with and as specified in the RM Springfield Aquifer Capability and Groundwater Vulnerability Study, quote, a professional hydrogeologist or a hydrogeological engineer prior to approval. 723(1) also refers to an Appendix D, figure 32. It's a groundwater sensitivity map that came from that same aquifer study. Now, the study states a larger number of groundwater sensitive areas were mapped in the eastern regions of the RM in figure 31 than in figure 32. As a result, the full composite plot shown in figure 32 does not highlight some of the more localized and isolated deposits identified in figure 31.
What section are you looking at now?
I am looking still at 723(1). It's just a paragraph. I request that both figures 31 and 32 be included in that Appendix D so that it can be referred to for development appropriately. I'll skip these and I'll leave a paper that I have that I'll give to you. And 4.2, general definitions, livestock, remove not including bees. Bees must be included in livestock definition to comply with the Livestock and Livestock Products Act definition. Now, my next point is on 4.6, that's the industrial use class definitions. Now, what I'm going to read here is based on changes that many have not seen, including me. And so calling this public hearing so soon without an appropriate length of time for people to read those new changes puts many at a disadvantage. And in my opinion, this hearing is premature. But I want to say this on the addition of mineral operations, because I'm not sure if I'll be able to come back here and if who knows what's going to happen, if it'll come back, but adding mineral operation to this zoning bylaw, wherever it may be, such as in clause 4.6, as suggested, is contradictory to what Springfield and neighboring residents have said regarding mineral extraction in our shared aquifer system. In their report on the Silica Mine project, the Clean Environment Commission stated there was no confidence that all potential effects of this project have been fully considered and that adequate detailed plans have been prepared for preventing or mitigating these effects. Hence the proper denial by the province on the project. And the second proposal recently filed again fails to provide that required information. That is a red flag. And until science can prove that the project is environmentally, fiscally, and legally sound, we must not entertain mining in the zoning bylaw. 2,241 of the 2,273 comments made on the project were not in favor of it. The rest were from citizens of, I should say that these were from citizens in neighboring municipalities. Clearly, this points to disapproval of putting mining in our zoning bylaw, a bylaw that is developed by the people to direct where and what type of development can occur in the RM. So I request that mineral operations must not be considered in the bylaw. Point 6, zoning bylaw 0801 correctly contains SNR, the sensitive and natural resource. I feel that it should remain in this zoning bylaw per section 75 through to 75.6, paragraph 4 of 0801. I'll skip the hazard lands. It's in the paper that I'll give you, 7.14. That's landscaping and buffering. It fails to cover agricultural operations, and these things support watershed resiliency, enhance water quality and biodiversity, reduce soil erosion, ensure neighboring properties are not negatively impacted. So I request that a shelter belt protocols for farmyard, agricultural operations, livestock facilities and fields, and I request that a 5-row eco buffer design be implemented. I won't go into detail about the eco buffer and what it is, that's all available there. 9.24.3. I'm going to defer to Dr. Breshka to go into detail. Hersak. But I will say a minimum 20 acres is more appropriate for residential related farms, not 5 acres. And I will finish with this, my 10th point here. I understand that the Mines Branch comments were made in 2021 with the former government that was found guilty and fined for inappropriate behavior pertaining to the silica mining project in our area. A Mines Branch comment was made in 2024. However, that's prior to the filing of the second silica mining proposal for the area. The branch's comments have not been revised for proposed bylaw 2609. That I know of, to ensure meaningful public engagement and unbiased, informed decision-making. I request that until the proposed project goes through the assessment and licensing process under the Environment Act, until the public inquiry into the proposed project is completed, and the Mines Branch provides updated comments, the municipality defer, including mineral operation and the MRP zone, which was drafted specifically for the proposed silica mining.
Thank you, Mayor, and thank you for your presentation, Ms. Bell. You know, you're a champion. You protected our community against this silica mining operation. So my question is very simple. Are we vulnerable with the way it is proposed this evening that this could open the door for this second proposal by Silica? If we leave it the same way as presented tonight, are we just saying, welcome, come on down?
So that was 15 minutes of unmute.
Oh, I heard it.
It was said just the last 2 minutes, so I don't know if it clicked on or not, but
It's not recorded though. Not a problem. So we'll get back to the question here and hopefully everybody can hear me. Again, I do not privy to these new things that have been updated and on the today. So I'm at a disadvantage, but from what I read and from what I have understood, this is my opinion, is we are incredibly vulnerable. And yes, it is water. We hear a lot about people saying water is a provincial thing, but no. You know, our development agreement, not development agreement, our development plan, it does indicate that water is specific, that it's very important. And regardless, even if it isn't in there, we're human. We're all in this together. And let's start realizing that our environment, that's our life support system. And we have to start developing policy that is respectful of that and humble to it.
And I liked your comments that it was a previous provincial government. This new government is taking this seriously, is looking at protecting human health and the environment, and that we're in a different chapter. And we need to get on with being on a different chapter in our municipality to protect our water for generations to come, not just for yesterday or today, but for generations to come. With this current document, I don't feel confident that we're doing that.
So I'm muted. So I agree with you. And even in the Ethics Commissioner's report, when you do read it, you start to see that there is what people call regulatory capture. And it's just not about the elected officials, but we also have to start taking a look at our regulators and the ministers in charge, or the deputy ministers in charge. These individuals in that Ethics Commission's report were quite clearly compromised. These people are still around. There have others that are not in the report, that were not covered in the report. But so we really need to see that public inquiry, and I'm hoping that the public inquiry goes through the entire handling of the CO Silica affair, from processing the rail. And we have to remember that the rail and the processing facility, it was licensed by the very individual that was caught and fined in the Ethics Commission's report. So that is clearly, there's some issues there that need to be looked deeply into before we proceed with opening up the aquifer system that it was shared by all of us in the RM of Springfield, including our surrounding areas.
Thank you.
Thank you.
Thank you, Mrs. Bell. Are you a resident of Springfield, sir? No. Okay, whenever you're ready.
I'm Wesley Mustard. I live on Ridge Road. Wesley Mustard, Venture Road 32 South. Good evening, Mayor, members of council, administration, and fellow residents. I appreciate the opportunity to speak regarding the proposed zoning bylaw 2609. Tonight, I want to focus on one simple question. Does this bylaw actually follow Springfield's own development plan? The development plan is supposed to guide every zoning decision this council makes. Both the existing bylaw and the proposed bylaw states that zoning must be consistent with the plan. This is not optional, it is a foundation of good planning. The development plan identifies Vivian as a general development area. It envisions larger residential lots, limited compatible community activity, and most importantly, protection from incompatible land uses. Unfortunately, this proposed bylaw moves away from these provincials instead of reinforcing them. Council previously changed the wording from general development area to hamlets after residential raised concerns. But changing a name does not change what is actually permitted. If the land use permission remains the same, then the change is cosmetic, not meaningful. Another concern is the new mixed use zoning. The bylaw contains no clear definition of what mixed use actually means. If residents can't understand what is permitted, how can they know where they are being asked to support? Unclear definitions create uncertainty, inconsistent interpretations, and unnecessary conflict. So I respectfully ask council, how can you conclude this bylaw is consistent with the development plan when it weakens protections that the development plan specifically promises? How can residents have confidence in a bylaw that contains undefined land use terminology? Good planning should provide clarity, not confusion. Before adopting this bylaw, council should clearly demonstrate how each section complies with the development plan, provide a precise definition for mixed use, restore the protections intended for general development areas before final approval. Residents deserve a bylaw that is transparent, consistent, and faithful to Springfield's long-term planning vision. Thank you.
I apologize, Weston, there. I know you did well, you're splitting image. So it's, I didn't quite get my glasses on in time to figure it out. Thank you for that. Anybody else, there that I guess? Sure. Yeah.
Good evening, members, council, administration.
Just state your name.
I'm getting there. And fellow residents, my name is Hunter Mustard, and I'm glad to have found the time to speak regarding proposed zoning bylaw 2609. My comments focus on what this law could mean for the people who live in Vivian. Planning documents can sometimes seem technical, but their efforts are very real. Under this proposed bylaw resource, manufacturing uses may be permitted immediately across the railway of homes from homes. That definition is extremely broad. It includes activities associated with quarrying, mining, mineral processing, washing, crushing, screening, blending, storage, and handling of raw materials. Residents could one day find themselves living beside industrial operations that are completely incompatible with the community envisioned in Springfield's development plan. So I ask the council one simple question. How does permitting these industrial activities beside Vivian protect residents from incompatible land uses? I am also concerned about transparency. The existing bylaw included a separate map Vivian map that made nearby zoning easy for residents to understand. That map has disappeared. Zone boundaries have changed. Development reserve permissions have changed. Industrial extractive zoning has changed. For the average resident, it is now much harder to understand exactly what has changed around their property. Good planning should become easier for residents to understand, not harder. Perhaps most concerning is that many affected landowners feel these changes have occurred without meaningful consultation. If this bylaw truly benefits the community, residents should not have to struggle to understand it. I respectfully ask the council to remove or significantly restrict incompatible industrial permissions adjacent to Vivian. Restore clear mapping that identifies every zoning change affecting the community. Meet directly with affected landowners and address their concerns before this bylaw is adopted. The decision will shape Vivian for many years. Please take time to get this right.
Mr. Mustard. I'm sorry, Mr. Russell, what was the first name?
Hunter.
Hunter. If you could just keep your hat out there, Hunter, appreciate that. Who else is coming up for opposition there? Matt?
Dr. Elizabeth Hersack, Navin, Manitoba. Thank you for the opportunity to be able to speak. As I had said earlier, I have a letter of objection to the proposed zoning bylaw 2609. And I will provide you a copy of my presentation. My objection to the proposed zoning bylaw 2609 is for several reasons. I could list more, but I have 4 that are, I feel that in my area are quite a priority. I don't have a large graphic, but this is the RM of Springfield. This is highlighted in yellow is me, where I'm at the most southwestern portion of the municipality that is bounded between the South Perimeter Highway and the Red River Floodway. My main reason, which I have at every opportunity to object, has not changed, whether it's been with the proposed previous bylaw of 2125 and now with the new bylaw draft of 2609. Land zoned under current zoning bylaw 0801 and any amendments to it should not be unilaterally changed by this proposed zoning bylaw. The reason that land has been designated a certain way in the current RM of Springfield Development Plan, number 1809, is by no means justification that the land in future zoning bylaws should be changed to the same land use designation. I know that this has been a discussion point, that we have a development plan and the zoning bylaw has to match the development plan. The development plan is a long-range planning guide. It sets out how future development should occur. When land use changes, it should be based on a number of objectives and policies that are set out in the development plan. So I'd like to provide you with an example. So the land that is situated in the southwestern part of Springfield, and that would be sections 5, 8, 9, Township 10, Range 4 East, and it's separated by the Red River Floodway and the South Perimeter Highway. It is primarily zoned AR, ag restricted, with a mixture of rural residential properties under the existing zoning bylaw 0801. In the development plan, it is all designated, that entire area is all designated as RR, rural residential. In the proposed zoning bylaw and the previous bylaw draft 2125, it is also entirely zoned as RR, rural residential. Landowners from this area have not been consulted and have not promoted this land use change. In fact, this change would greatly limit what owners and future owners will be allowed to do on their land. Furthermore, in section 6.4.3 of the development plan, rural residential lots west of the floodway, that's inside the floodway, shall be a minimum of 4 acres in size. This would make any of these 4-acre properties actually ineligible to permit an equestrian establishment or a rural residential related farm usage. Because for those 2 uses, the minimum property size required is 5 acres. Thank you very much. I happen to be on a property that's larger than 5 acres, but for individuals that would be looking to perhaps purchase property, you drive around, you say, hey, I would like to live in this area. Well, guess what? If you're purchasing a property that's under 5 acres, you are now not going to be eligible to pursue those other things, whether that's a couple of horses, a nice little Jersey cow to have in the yard, some goats, potbelly pig, what have you, not happening. This is not in keeping with the rural nature of this area. At the present time, this week, there are 7 active listings of residential lots for sale. They are all listed as 4 acres, ranging in price from $289,900 to $349,900. Well and septic not included. Area subdivision applications have all been for the minimum acreage requirement, aside from one subdivision application that was approved for 2 additional rural residential lots for a current area family that reside here. They've been longtime residents, and each lot size was 5.74 acres, which would allow these other activities to happen if that was approved conditionally. In the West Pine Ridge Secondary Plan, bylaw number 2121, new rural residential lot sizes shall be a minimum of 5 acres. Rural residential lot sizes outside the floodway are also a minimum of 5 acres. Question I have is this a conscious attempt of this council to negate the rural lifestyle we have enjoyed in this area and encourage large lot estate property development, or far worse, the potential of annexation by the city of Winnipeg through a failed WMR? Just so you know, in gray is the city of Winnipeg relative to where I live. I actually get 2 tax bills, one to the RM and one to the city of Winnipeg. Part of the development plan vision, section 2.2, highlights the rich equestrian way of life in our municipality and efforts to protect the robust and diverse agricultural industry. I see neither of this in these proposed land use change and reduction of property parcel lot size. The RM of Springfield Development Plan states that the decision of council related to land use and development will be based on goals, objectives, and policies of the plan. It goes on to say that it will provide guidance and direction to both the public and private sectors with respect to future development of land, and will ensure the timing of such development coincides with the appropriate provision of public services. Property owners in this area have very limited public services, and fire protection is distant. Access to the area has been made more challenging by fairly recent and ongoing changes by the province to the South Perimeter Highway. This will continue for many years to come. The proposed land use change will create a premature increase in small 4-acre lot development, reduce agricultural use of the land, which will change the character of the area forever, create increased traffic volumes, and fuel concerns about groundwater quality and water table strain with increased densification, as each lot will require a well and septic field. There is no secondary or sector plan to facilitate with future developments such that the area impacts would be considered and addressed as development occurs. This land use change does not meet many of the goals, objectives, and policies of Springfield's development plan. The change in use is premature because there is currently a significant amount of undeveloped land zoned rural residential in the RM. Land parcels that are actively farmed or have associated agricultural activities should be protected for agricultural use. In the Municipal and Northern Relations Report regarding the proposed zoning bylaw 2609, it was noted in one of the memorandums dated July 22nd, 2026 from Ashley Beck, Manager of Roadside Development, Province of Manitoba Transportation and Infrastructure, page 15 of the original report package. It was noted that in future, access to PTH 100, that's a perimeter highway, from the rural residential zone proposed along PTH 100 and north of the floodway will be limited
to Symington Road intersection. So another question I have is, will this area only have one point of access? And if so, for what time frame? If the municipality is promoting higher density in these areas, then it should first prepare a secondary plan or at least a concept plan for future development and road access related to concerns such as traffic, fire protection, emergency services, access, etc., and not change the zoning until these plans are in place. This would help to establish specific objectives and policies aimed at managing growth and development that is well planned and coordinated in accordance with the goals of our community and supporting any future development with appropriate infrastructure. The development plan is intended to direct future development to appropriate locations and to provide standards and guidelines for development. It is a long-range plan. The RM of Springfield's original development plan was adopted in 2001. In 2016, a comprehensive review began for drafting an updated plan with first and second readings in 2018, and finally a new development plan adopted 1809 on February 5th, 2019. As per section 1.1 of the development plan will undergo periodic reviews, providing council and the public with an opportunity to adjust policies as necessary. In future, policies may need to be amended in order to more accurately reflect new conditions or unanticipated changes to local conditions and values. As per section 12.1 of the development plan, the RM of Springfield must complete a detailed review of its development plan within 8 years after the development plan is adopted. That would be by February 5th, 2027. My question to council is, when will this occur? Perhaps these matters of adopting a new zoning bylaw and review of the development plan could be done in tandem with a newly elected council, WSP, and the residents of the RM of Springfield. Please do not assign a new bylaw to an old document and restart the process without acknowledging how we got here. And there are other areas that have been changed. I'm merely using this as an example because I have firsthand knowledge and I have a lot of skin in the game. It is my home, my property, where I live and where my family, my residents, my neighbors all live. I'm here today probably representing at least 30 residents they're frustrated, they're tired, they're angry, and they just would like to have some assurances of what this will look like going forward. My next area of concern is, and I had alluded to it in question period, is the equine establishment. There still seems to be some confusion with definitions of horses being livestock by definition, but not being considered livestock according to the livestock overlay map and zoning definitions in this bylaw. Excuse me. And just as an aside, both poultry and bees are also considered under provincial livestock regulation and for disease management as livestock. Bees are considered livestock under the Provincial Livestock and Livestock Products Act. Springfield's development plan restricts livestock operations at varying levels depending on the livestock operation policy and land use designation, which then corresponds to various livestock operation overlay zones. This is this table 9-3. Many of these areas are now designated as livestock operation restricted, and it creates an awful lot of confusion. One relates to commercial livestock operations, but the equestrian establishments relate to like a different aspect in zoning, non-commercial. I would suggest that you would expand the information stated in footnote 2 of table 10-1, residential and mixed zoning district dimensional standards, to expand on the minimum site requirements for equestrian establishments and also to residential related farm of 5 acres. Given for time, I will also preface that the same could be also said for residential related farm use. The confusion in terms of zoning, what's required in the L4 livestock restricted overlay map. The poultry keeping, the animal control bylaw 1803 of Springfield defines poultry in the category of livestock. However, in that bylaw, there's not very much pertaining to livestock. I would suggest that this not be included as it is in the current zoning bylaw. If there is an interest, I would strongly encourage perhaps a pilot project. There is an awful lot of information that is missing in terms of housing, in terms of things like pest control, how the animals are going to be handled, etc. And also, even if your animal control officers are able to house a bird if they have to. And lastly, in closing, I do hope that you will consider, there is a housekeeping issue that 9.25.2 has been used twice, just so you know. And in closing, I would welcome the opportunity to work on making this a better bylaw. Everyone has a role, everyone's voice matters. The best outcomes happen when hierarchy does not silence wisdom. The question should always be, who is still outside the circle and how can we bring them in? Thank you.
Thank you, Mayor, and thank you, Dr. Herzog, for the expertise that you bring to this chamber, the expertise you bring to this document. We didn't have it. We need it. We need to continue. I know you didn't actually complete your document or your presentation, and there's so much more that we could yield from this, that the development officers, that this whole community could learn. You know, the two people out of, he used the word, 2 people out of 17,000 who are in favor of this document. 2 people, and he diminishes the 900 that are on some petition, and the number of packed people in this chamber and outside the chamber diminishes all that. Your presentation alone shows us there's a lot more work and a lot more devil in the detail that we need to incorporate into this document for the benefit of our community. So to say that let's just pass it because we've spent so much time and effort and all the rest of it leads me to believe that we have either inept members of council who would do that or people who don't give a darn. We need to do it properly, including all the elements that you talked about, all the elements that others have talked about. We're far from the finish line. We need to be absolutely engaged with the public, and no one will ever convince me that we've done a great job with doing that to date. So thank you again for your presentation.
Thank you.
Just a note, Councillor Miller, I find it offensive where you refer to some council members as inept there. I don't think that's conduct becoming there. I think it's up for the public to assess that. But was there anybody else?
Well, yeah, what time is it? How long are we going?
Yeah, it's 10:30. We can go to 11. But I think we're finished everything here, so it's up to council here at this point here. It's up to council there. We have other homework to be done. We have.
Presentation sometime for another night.
I'm sorry. So we have other homework to be done there, Deputy Mayor.
Yeah, I think where we're at right now, we keep the public hearing open and we have another meeting. We can arrange that other meeting with you out council tonight. So everybody knows when the next meeting is. I think we need to do our homework more. Like I said, the last report that we have, I've never haven't read it. I've read the Manitoba report, the first one, but I haven't read the second one, and I also didn't read a couple of the objections that came in at the last minute. So there is more homework that we need to do, and I think we need a fair amount of time to do that in. I recommend that we at least postpone this for 2 to 3 weeks at least for council to have things in play and everybody's read everything. I can tell you this, and I'd like to share a little more with you on this. I've sat on council for 12 years, and you know, when I hear that, you know, we didn't do our job, I can tell you that we had many open houses throughout the development plan. And I know there is a few people in the audience here as residents that participated in those open houses. I can tell you through the development plan, and this is the way it is that those open houses did happen. Certain people didn't come out to the open houses because you know what? They were like me before I became elected. I was there busy with my life with my children, and we were doing other things. It wasn't a priority, and that still happens. That's why I will say this, that's why there's not 17,000 people sitting around the table here today, because people have their lives and they don't always just do all municipal work. Okay. I was one of them. So again, residents miss out on things, and then they come into the plate and say, well, I never was part of this. Well, no, it was publicized. All the open houses were publicized. I was at all those open houses. I started with Bob and Arik as the Reeve. I know I was at them. I know Councillor Kuczynski was at some of the meetings too. I've seen him at some of the open houses. So it's all part of the mix. So today you're here, but yesterday you weren't here. So remember that also. Council of the day was doing the best they can at the time. So now this council today is going to do the best that we can at this time. We're hearing everybody. We're listening. We'll take everything and we'll bring it back to administration. I want a meeting with administration to review everything, make sure I understand everything so that the public knows. And that's where I'm coming from. So again, there's been 12 years of this. We're not wrong. This is a zoning bylaw has been in play for 8-9 years. The development plan has been 12 years. I can tell you that. And there's been many other plans part of these reports that have many open houses. So don't say that we hadn't done our job. I can tell you for 12 years, we've done our job. And that's why we're here in an open house or at a public hearing today to do our job, to listen to everybody. Yes, maybe we needed a bigger facility today, but you know what? We're doing the best we can. We don't know how many people are going to come here. There is no system to say, oh, there's going to be 100 people here tonight, or there's going to be 200 people here tonight. Because I can tell you that we've had a public hearing out in Cooks Creek, rented the facility, and we had maybe 20 people there, expecting 300 people. So it happens. It happens on both sides. So please respect council's doing the best that they can, and that's what we're doing. So tonight, I ask that we defer it, I guess, or carry it on through another open house, and we pick a date to when this is. Thank you.
Thank you. Councillor Kuczynski.
Thank you. I want to point out, Councillor Fuel, that you're saying that was a lot of meetings and lots of work was done. Nobody denying that, except the outcome wasn't there. Because municipal board rejected twice this municipality. If we have properly done our zoning bylaw, they will accept it. The changes what did they state it is that have to be required? Yeah, that have to be changes have to be required in that new zoning bylaw. How come we didn't adopt it what was presented to us by province in 2024, June 19, 2024, and we didn't adopt that? They're reminding us now, do it, or it's not going to go through again. So how this happen? Who is responsible for that? Those requirements wasn't included in our zoning bylaw. Somebody must to be responsible for it. We're not against the change doing the zoning bylaw. We want a zoning bylaw that suits our residents, not anybody else. And a lot of people don't come here like, the two presenters who was favorite, they coming and criticizing myself like I would be against the zoning bylaw. I am not. I never stated I'm against the zoning bylaw. I don't know where this resident coming from. The other residents saying that we need development for any cost. We need development. Who's going to be paying for it? Are residents going to be paying for it? We need the water treatment plant. We need lagoon for the new expansion. On who's going to paying for it? Our residents. Why are we going to pass the zoning bylaw that the residents going to be on the hook for all this expansion? It's developers. They want to come here. Let them pay for it. We're going to welcome them with open hands. And we don't want here somebody saying we have to have affordable housing. What is affordable to who? Nobody can define that. We're talking with developers, they're saying to us, we cannot build affordable housing. The cost of the material, labor, and all the restrictions, what they have to go through, that everything costs money. So we're not here to delay everything. We want to go forward with the zoning bylaw, but have to be good, have good and be palatable for our residents. That's who we're serving here today. We're not serving anybody else. And they're saying that, oh, we only have 900 people who signed the petition. Did that gentleman even know what he's talking about? He ever did the petition one in his life? How much effort that required through all the people that put their hearts to it to get those signatures. Nobody even take that in consideration, but somebody gonna, complaining about it. And residents only have 2 weeks to do that work. If they have 3 months, they probably maybe have 15,000 signatures. People, I never said yet somebody come to me and said, oh, I want to spend more money for taxes so developer can make a higher profit. Find me one resident to do that. But yet council is for saying, oh yeah, we just have to do it because we have to have affordable housing. We are rural area and we want to retain the rural area. Yeah. Nobody is saying that we have to become urban area here for some reason, and we have no employment for these people, and they don't be traveling to city of Winnipeg for employment. We're creating congestion, we're polluting the environment. Nobody talks about that. So let's make sure that we're doing right for the resident. Thank you.
Okay, it's 10:34, we can,
The
council to say so. We can have a resolution there to extend to 11 o'clock, and that's what we need right now, is a resolution.
So if this is the last item, just council deciding on the next steps, we can just finish that item off without extending to 11. So I think the recommendation is that we need a larger venue when we rebook. I know that staff want to review the provincial report in more detail and set up a meeting with the province to get some more information on what's required and recommended and bring that information back to council. Give some time for council and residents to review that revised provincial report that came in today. We will have to re-advertise because I can't guarantee a location that's available on a certain date and time. So at this point, I think that's just the recommendation that council adjourn and keep the public hearing open, and we continue when we have a venue set.
And is the date going to be August the 20th?
I don't know. We have to find a location that has a date that's available, look at our timing for publishing notices, and make sure that we can get all the answers we need from the province before we book a certain date. But we'd be looking at close to the end of August, yes.
But if we're going to adjourn here and it's basically still open, are we not to have a date?
You only have to set the date, time, and location if you don't want to re-advertise. I can't give you that information today. So once we have that set, then we will just have to re-advertise.
Okay, everybody understand that, Councillor Miller?
Thank you, Mr. Mayor and CEO. highly recommend that we push it into September simply because August is kind of a write-off. I know administration is going on a bit of a break. For people to re-engage, they're busy with their families, as Councillor Fuel has said. We really want people to be active in this. And to be honest, I mean, administration too may be on holidays, as I mentioned, but I don't know if you can put your foot to the pedal and get this all done. You have to have discussions with provincial representatives who are probably on holidays as well throughout that period of time, and on and on. Again, I'm all for what Councillor Kaczynski said. I want this done. I want this to be a perfect or a near perfect document for us. I want to safeguard our water, as Ms. Bell had said. So those have to be integrated into this. And it's a no deal for me if that can't be part of it. So please, September would be probably the best option.
Well, I think why don't we just let them decide what days are going to work. I think that's putting it pretty tight to September, but that'll be up to administration to find a date, the location, and so on like that. Councillor Warren, anything to say?
I would have to agree with all of you gentlemen that we need to find the bigger venue. And yeah, the province, the communication with the province to actually sit down may take us a while. And then to bring all that information back to council, that's another. So we will probably have to look at the end of August or beginning of September.
Okay.
So let's pause. And then once they have a date, then we can advertise everything all at once.
Okay, I think we got consensus on that, Councillor Kaczynski.
And I would suggest that council have meeting with our administration and review all this new information what we got from the province before administration send something to the province, because we have to have decision made by our council. So
What about us?
yeah, and then have to be presented, I guess, to the residents.
Where do we fit?
Yeah.
Okay, well then,
Thousands of dollars
I think,
protecting our community.
sir, let me speak, all right? You're being disruptive, Mr. Akins.
That's right, I am.
So at this point here, then I'm prepared with everything here that we've seen and heard. I want to thank all of the people in the audience, with the exception of Mr. Akins' last comment there. Everything else went pretty well tonight there. So everybody got some good comments in there. And once again, sir, at this point here, I'm prepared to adjourn the meeting, and we'll get you a date there in August coming forward. If I get a show of hands to adjourn the meeting at 10:39. What's that? Oh, can I get a mover and a seconder then to adjourn there? Fuel and Warren? Then I get a hands of support for adjourning the meeting for the next meeting date. That is unanimous, and so passed.